As Tyler had mentioned before, I'm known as Grantee Major. I come from a banking and investment banking background. I spent about 15 years on Wall Street. Worked on all aspects of finance, everything from the commercial markets to trading and investments, investment banking and banking itself. So I had the opportunity to get a lot of experience with financial instruments, securitizations, mortgages, stocks, bonds. So it only came natural when I came across this information about commerce and how things really work behind the scenes. I was intrigued, and for the last, I would say, 4 years, I've been soaking as much information as I can as possible. And having that unique perspective of finance and really understanding financial instruments, I think, gave me a quicker learning curve, because for most people, these instruments and these processes are like Greek. So they're very difficult to the layman, and it's a whole different language and vernacular. So you'll get a unique perspective tonight in terms of how I see things, and everything I say tonight is, just for information and entertainment purposes only. We're not offering legal advice, but we are offering a perspective that you may not have looked at before. So based on that, let's get started. The name of this webinar is Status and Standing. And one of the main things you may want to consider or ask yourself is, what is your status? I know that you guys did a series on status correction and the whole secured credit process, but what is your status? Can anyone type in some responses to what they believe their status is in commerce and at law? Like, if you had to answer that, what would be your status? So Chris says slave. Well, that's definitely one perspective, and I think the state agrees with you on that one. Okay. Someone says my status is American national. That's Tom. And anyone else? Slave. Equity. All right. What do you mean by equity? Because as far as I know, equity is not really a status. It's more like a remedy or a claim. You could have a claim in law or a claim in equity, and equity compels performance. What were you trying to say with equity?
You could also hit the unmute in the left column there, the little line through it, and they can elaborate by speaking to the mic if you choose to unmute them. And then just make sure you mute them back when they are done speaking, so yeah.
Which one is that? I see Chris. Which Chris is that? No, it's Chen. Okay, Charles, you're unmuted. Did you want to elaborate a little bit on what you meant by equity?
If you unmute them and they don't have their mic set up, then obviously you'll know and they won't be able to speak, but give them a chance to try to plug it in, and if not, just move on.
Sure, no problem. Let's look up equity.
My answer would be a state national. State national of the republic, the original jurisdiction republic. That's my answer.
Okay, those are all excellent answers. So before we move on, I want to make sure that everyone has a good understanding, because words are very important, especially when you're talking about legal terms. So equitable remedies are judicial remedies developed by courts of equity from about the time of Henry VII. All right. without getting too much into it, before the courts of chancery, people had remedies at law. So they separated the laws of the courts of law and the courts of equity. And in the United States, the courts have been united. So a court can deal with issues at law and deal with issues at equity. So one of the main equitable principles is he who comes to equity must come with clean hands, i.e. the court will not assist a claimant who is himself in the wrong or acting for improper motives. So that is equity. So someone who is an American national, someone who has proper status or standing, can come for a claim in equity, if that's what you meant. But someone who doesn't have any status or standing cannot have any claim or equity remedy at law. So I just want to make sure that that's clear for everyone. Okay. Let's see. Okay, yeah. Without proper standing, no justice or equity. Okay, excellent. So we're on the same accord.
Maybe you could read.
So that's clear for everyone.
Click back and read that first paragraph, if you would like to.
For the equity?
Yeah, I saw something there that, if it's not too hard to grab that back. Because it says, clicked off too soon, my friend. Equitable overview. Equitable remedies were granted by the Court of Chancery in England and remain available today in most common law jurisdictions. In many jurisdictions, legal and equitable remedies have been merged, and a single court can issue either or both remedies. Despite widespread judicial merger, the distinction between equitable and legal remedies remains relevant in a number of significant instances. Notably, the United States Constitution's 7th Amendment preserves the right to a jury, trial rights in civil cases over $20 to cases at common law. I just wanted to read that because it's talking about common law. It continues on, keeps talking about common law. So my question is, how does common law apply to what you're talking about? Maybe you can just, I mean, I'm sure you're going to morph into that with where you were going with it, but I see common law, common law, common law, common law. Everyone wants to be in common law. How can we be in common law and get remedy in common law?
Well, first, I think it's important to define common law, and very few people can actually really understand what common law is, but there's a section that we will get that will go into different types of law. So it was Article 7 of the Constitution? Let me see.
Yeah. Said that, yeah.
7th Amendment. Okay, 7th Amendment, not the Article 7. Okay, I actually happen to have the Constitution open. So, Amendment 7, trial by jury in civil cases, ratified 12/15/1791. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. All right, which were ratified, which was, common law came from Britain. It was the series of case histories and precedents that were later codified and ratified, which were observed by the colonists, the original colonists, 13 colonies that made up the original United States of America. And then you have American precedents and case law that have been incorporated into that, and then you have all the codes and statutes which make up our injustice system today, just for a quick overview. But let's get going. Now, understanding status is essential. All individuals take a position at law and in commerce when entering into an agreement or contract. Under natural law, there is no limit to your rights and the power to contract unless you waive or limit those rights by consent or tacit agreement. Your status plays a big role in determining your position when it comes to the enforcement of your rights and claims in commerce and at law. Some of the ways that we limit our rights or our power to contract is through what's called adhesion contracts or unilateral contracts. Can anyone think of what would be considered an adhesion contract or a contract that may limit their rights or limit their ability to contract? One of them could be the birth certificate, which was a big part of the SPC process, right? SS5 application, yeah, exactly, Social Security application. Signing up for selective service, signing up for jury duty, or not jury duty, for voters registration, right? W-2, W-4, which identifies you as a taxpayer, U.S. passport application, DMV application, signing up for financial aid, signing up for the military. Those are all contracts of adhesion that create, not only does it create a limitation on your rights, but categorize you as a debtor, but those are all what's called hypothecation events, right? And we're going to go more into that later, but I just wanted to see where everyone stood with that. So we had some good answers. Thank you. All right. So the issue of status in commerce is strictly one of how we enter into contract. In doing business with the United States and or its agents, we are the source of commercial energy in any contractual relationship. Commercially, we typically are engaged in transfers for most transactions. Transfers are activities that take energy, goods, and services from one party, but no value or detriment is received in return. The nature of this oppression is mostly invisible. Americans are forced into an economic and political slavery by an elitistocracy and consortium of international banksters through unlawful foreclosures, forfeitures of property, and a war on crime and drugs. Right? I'm sure some of you have experienced some of these transactions and have been the victim of them. Right? Since the Civil War, the state has usurped its power from the American people through bureaucratic threats, duress, coercion, and manipulation of the economic and legal system. The state has been at war against the American people since then. The government bureaucracy took advantage of the civil disobedience and dissent to strip Americans of their sovereignty and has been chipping away at the limited authority and jurisdiction enumerated and placed upon the federal and state governments through the Constitution and Bill of Rights. Now, how did this happen? Right? In 1863, Lincoln declared a state of martial law and suspended the writ of habeas corpus. In 1861, through the General Orders 100, also known as the Lieber Code, which has been adopted by many military in other countries as the code for government armies in the field. This code was authored by Francis Lieber, or Franz Lieber. He was a German jurist and political philosopher from Prussia, Berlin, Germany, and he was a professor of history and political science at Columbia College, which is currently known as Columbia University. Lieber assisted in the War Department with President Lincoln in drafting legal guidelines for the Union Army. These guidelines became known as the Lieber Code. Now, under Article 4 of the Code, martial law was defined as follows. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and of the domestic administration and government in the occupied place or territory, and in the substitution of military rule and force for the same, as well as in the dictation of general laws as far as military necessity requires the suspension, substitution, or dictation. The commander of the forces may proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by military authority. Now, how many people have heard before that a lot of these courts are military tribunals or courts under admiralty? Right? How many people have heard that before, heard that claim before? Well, this is where it comes from, because when the state of martial law was declared, the United States came under military rule, almost like a foreign occupation. And under Article 2 of the Code, it states, martial law does not cease during the hostile occupation except by special proclamation ordered by the commander-in-chief or by special mention in the treaty of peace concluding the war, when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. What that basically is saying that unless it's a proclamation or some treaty that's been formed, the martial law does not cease. Now, Lincoln was assassinated shortly after the war. He never declared or issued a proclamation of peace or reneged on the martial law, and also Congress never issued a treaty or a proclamation with the American people. So if you're under martial law and under military rule, then everyone is, is subject to that unless you opt out of it. And by the adhesion contracts that we talked about before, that's how you give your tacit agreement to limiting your rights and to contract. Does that make sense to everyone? Do we have any questions so far? Okay, good. Now, Lincoln was assassinated shortly after the end of the Civil War, and General Order 100 was never repealed, or peace was never officially declared. Accordingly, Americans have been under a perpetual state of war of the United States and under military rule and occupation ever since, right? So that is where you get all these laws and Article 1 and tribal military tribunals and administrative courts that are administrating you because you are considered an enemy of the state. One of the biggest, hold on, let's see if there's any questions. All right. One of the biggest changes after the Civil War was the new status of citizen was created, right? The original Constitution for the United States of America was written as a contract or a compact between the federal government and the District of Columbia and free white males of the 13 original incorporated colonies that became states called the United States of America. A lot of people are not aware that not even white women were considered some citizens under the original contract. So the indigenous and aboriginal tribes that were here before were not incorporated into that. Neither were the descendants of the slaves that were transported here and those that were here from before. And the only people that could be nationalized under the Naturalization Act were these Europeans or those that descend from Europeans. So it wasn't until the 14th Amendment that even the white women were able to become citizens of the United States. So even today, the only class of citizenship available to non-whites is the 14th Amendment citizen. So after the war, Congress passed the 13th Amendment ending slavery and involuntary servitude. Then they passed the 14th Amendment creating a new class of citizenship called the subject citizen. A subject citizen was a corporate citizen or a subject of the de facto military government now in operation. Now, for the first time, legal entities, i.e. corporations, limited companies, and partnerships could become citizens under the 14th Amendment and have legal rights under this status, right? So under the 14th Amendment, citizenship rights ratified 7/9/1868. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws. So you see here it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof. Before that, the courts had ruled that there was no such thing as a United States citizen. You were usually a citizen of the state that you resided in or were born in. Does that make sense for everyone? Let me see if there's any questions. I want to make sure I get your questions because I'm going to keep checking back. There's a question here about what about Norman nobility? So we get your law from England. Are you saying Mormon nobility? Is that what you meant? I'm not sure of that question. Norman, I'm not sure about that question. Yes, okay. All right. So, and this is important, right? The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. So subject citizens, 14th Amendment citizens, cannot question the public debt. So that's why when you go into court and they say, how do you plead? And you plead not guilty, you are not agreeing to the public debt, and that's why they administer you, and that's why they lock you up. Does that make sense? So here we have the definition of denationalization. Denationalization is the act of stripping a national group of their nationality and political identity. An example of denationalization can be found in the 1947 Nuremberg trial of Ulrich Gerfeldt and others. During the proceedings, reference was made to the war crime of denationalization, citing the policy of forcibly Germanizing some groups within the local population of occupied Poland. Among the groups so treated were Poles, Alsaki-Lorrainers, and Slovenes, as well as others deemed eligible for Germanization under German's people list. So what they did with the 14th Amendment was denationalize natural-born citizens of the state, right, and make them 14th Amendment subject corporate citizens under the 14th Amendment. And it's all by consent and all by tacit agreement through these adhesion contracts, right? Does anyone have any questions so far? Tyler, do you want to chime in at all?
No, I'm good. I'm taking it all in.
Okay. All right.
Well, you're saying that basically you're saying that.
Go ahead.
When you go in there, the judges have this whole history of everything that you're reading about. This whole history, this whole case law backup, these whole precedents. The laws come in a combination of common law and equity and statutory and admiralty and all these things. You're saying that the judges are so smart and so skilled in order to get the position of being a judge that they have to know all this stuff, all this history, and they're in there. And when you go in there and try to communicate in layman terms to them and say, well, I want to do this and that or whatever, you're saying that the judges in their mind filter through everything that you're saying to them through their whole, every inch of research and knowledge that they've done in law school and beyond, and whatever maybe Freemasonic groups that they're in, or this and that, or everything that they know and everything that you're reading about the history and this and that and your status. They're filtering through to try to determine your status in their head without telling you. Like, they don't have a checkoff list and are checking off, but they're observing your actions, your conduct, your silence, and the things that you're saying, and they're determining your status in their head, and then they're treating you accordingly?
Yes, and what they're doing is they're working under assumption and presumption, because what they have in front of them when the case comes up, the case is an account, right? Every case has its own unique identifier, unique number, and on Chris it's an account, and they are enforcing international contract, right, which brings you under the law of the sea, because admiralty and maritime is the law of the sea, because each case is a hypothecation event. Now, that's the second time I use this word. I want to get to the meaning of it, right? So to understand the term hypothecation, as stated in Section 14A of the Act, right, of the Federal Reserve Act, is an offer of stocks, bonds, or other assets owned by a party other than the borrower as collateral for a loan without transferring title. If the borrower turns the property over to the lender who holds it for safekeeping, the action is referred to as a pledge. If the borrower retains possession but gives the lender a right to sell the property in the event of default, it is a true hypothecation. right? And under the securities, it's the pledging of negotiable securities to collateralize a broker's marginal loan. If the broker pledges the same securities to a bank as collateral for a broker's loan, the process is referred to as rehypothecation, right? So basically, what happens is whenever you do an adhesion contract, like for instance, let's say it's traffic court, right? And let's say someone is being administered for a victimless crime of, let's say, DWI, right? In many states is a misdemeanor, some states is a felony, right? So what happens is, based on, as soon as you fill out that DMV application and you sign it, that is endorsed and is securitized, which means that derivatives or bonds are issued against that. And then there are 21 dealers or corporations that dealers that buy these pledged instruments, and they become creditors. That's how the government funds its operation. It's funded years in advance, and they administer you through property taxes, through income taxes, through citations, through fines, through jailing you to pay the creditors back. And so when you're standing in front of that judge and he's asking you, how do you plead? He's asking you, are you going to pay or are you not? Are you going to stand under the charges? And do you agree to be administered under this jurisdiction, right? So if you don't understand your status as a man under the common law, and you go in there thinking that you are some juristic person, if you're thinking that you're someone, you're claiming to be a 14th Amendment citizen, then they're going to administer you as such, right? Because what is created is, from what you understood from the previous sessions, is a constructive trust is created when that birth certificate is issued and bonds are issued against it. And so you have been deemed a trustee as that because you never took your proper status as the executor of that estate. And so now you are the trustee and you are responsible. So that's why when you don't pay or when you don't settle the debts of the estate, you are jailed or you are fined or you are punished, right? And so that's why it's important for you to know your status and standing when you're entering into contracts, how to enter into contracts, how to reserve your rights, how not to subject yourself or claim any of the statuses, legal statuses of 14th Amendment citizenship on any of these applications. Let's bring up one of the applications. Like, for instance, let's bring up the SS5 application, and we'll show you what I'm talking about. All right? Just check to see if we have any questions. Is one
I sent out the wrong,
and the other?
I sent out the wrong. I sent out a link to the whole list, and it was the wrong link. I checked it, and I couldn't get on. So I'm sending out the new link now. So unfortunately, I'm sending a new link out, and then we should have some extra people popping on too as well.
The difference between the state of Pennsylvania, actually it's the Commonwealth of Pennsylvania, and the corporate state is one is the de jure republic, which was part of one of the original 13 colonies, and the other one is an incorporated municipality trading on Dun & Bradstreet as the state of Pennsylvania or Pennsylvania state. One is a corporate entity, which is an enclave of the United States. It's just a franchise, and then the other one is the de jure republic, which you have to invoke as either a natural-born or naturalized citizen of that state or commonwealth.
What is
is your question?
I think it's important.
All right.
That
so when you
just reiterate what you mean by a franchise, and just because it goes over people's heads. Number one, what do you mean when you say it's a franchise of the United States? And then number two, can you just reiterate one more time a little slower? You're saying that there's 2 Pennsylvanias going on here, there's 2 New Yorks, and there's 2 Texases, 2 Californias?
Well, there's the de jure, which means the lawful republic, which is the sovereign state which is operates by the authority of its citizens, and then there's the corporate instrumentality, which is basically an incorporated municipality or corporation that is operating in commerce. And they are all what would be considered what's a franchise, right? A franchise is an extension of a parent company, right? Like you see all those McDonald's franchise or Arby's or Dunkin' Donuts, those are all franchises, right? So each one has separate owners or people who operate it, and they all owe a duty to the parent company, right? They have some latitude in terms of how they operate, but they all have to follow, the rules and procedures, right? That's basically what a franchise is, right? So, all right, let's go over some of the definitions for the terms I've been using, right? So, nationality, right? Nation.
Hey, I looked up.
Yeah.
I just want to butt in because I looked up franchise on Wikipedia. Yeah. And it's very interesting. I found this very interesting. It says essentially the franchisor is a supplier who allows an operator or franchisee to use the supplier's trademark and distribute the supplier's goods. Who are the goods? You and me, the people.
Yeah, the chattel. Yep, the chattel.
In return, the operator pays the supplier a fee. And that's like all state court cases, all the CRIS system, it all goes up the line, all the money goes to the U.S. Treasury.
Yeah.
So, go ahead.
All right, no problem. So we were defining, let's define some of the terms I've been using. I want to make sure that everyone's on the same page. Thank you for that. That was a great definition. So the relationship between a citizen of a nation and the nation itself, customarily involving allegiance by the citizen and protection by the state. Membership in the nation. This term is often used synonymously with citizenship, the formal relationship between a ship and the nation under whose flag the ship sails. That's under corpus juris secundum, shipping, it's Article 1. A natural-born citizen is a person born within the jurisdiction of a national government. Now, under the Constitution, the original Constitution of 1776, the only persons that could be a natural-born citizens were white males, and particularly white male freeholders who own land, right? So anyone typically, except by becoming a 14th Amendment citizen, all non-white males cannot be natural-born citizens of the United States, right? So that is something that a lot of people don't understand, and a lot of people keep claiming the Constitution that they're natural citizens or that they have rights as a citizen of the United States, but the court has ruled that there's no such thing as a citizen of the United States. They can only be a corporate citizen of a corporate United States. And so a person can be a citizen, a natural-born citizen of the state that they reside in or that they were born in or become nationalized in, right? And federal enclave. This is a territorial land that a state has ceded to the United States. Examples of federal enclaves are military bases, national parks, federally administered highways, and federal Indian reserves. The U.S. government has exclusive authority and jurisdiction over federal enclaves. This would also include post offices and federal zones. So anyone using a zip code, right, is considered to be in a federal zone, thus putting you in a federal jurisdiction, right? And insert of possession is an island territory. National debt, the total financial obligation of the federal government, including such instruments as treasury bills, notes and bonds, as well as foreign debt, right? Okay, securitization. To convert assets into negotiable securities for resale in the financial market, allowing the issuing financial institution to remove assets from its books and thereby improve assets from its books and thereby improve its capital ratio and liquidity while making new loans with the security proceeds. So this is how the government is able to get new monies in and sell additional bonds and additional instruments by securitizing and selling it off to different creditors and making the American people the sureties for it. So pledging the commercial energy and the future labor of the Americans is how they're able to run their operations. That's why they're constantly running in a deficit, because they need to keep issuing more debt. That's how it works, because it would all come crumbling down if the national debt would actually be paid off. Right? So under our current monetary system, it wasn't until 1862 during the Civil War that the issuance of paper greenbacks as legal tender and circulating medium of exchange occurred. Under the pretext of the War Powers Act, Congress authorized the issuance of non-interest-bearing Treasury notes and declared the bills of credit to be legal tender for all debts, public and private, with the exception of taxes on imports. The notes were deemed necessary to float the debt of the United States for the war effort. On June 3, 1864, Congress passed the National Currency Act, also termed the National Bank Act, to provide a national currency secured by a pledge of the United States bonds and to provide for the circulation and redemption thereof. This act recreated the central banking system as a national association, which later evolved into the Federal Reserve Banks. All private banknotes issued under the authority of the act were issued and circulated the same as money, had to be redeemable at par value, 1 for 1 with the coin, and were declared to be tender for the payment of all debts, public and private, under Section 23. Pledging or hypothecating any of the notes in circulation under this act was prohibited under Section 37. And in 1913, Congress passed an act to provide for the establishment of Federal Reserve Banks to furnish an elastic currency, to afford a means of rediscounting commercial paper, to establish a more effective supervision of the banking in the United States, and for other purposes. The act is commonly known as the Federal Reserve Act. Some of the purposes for enacting the act were to collect 94% of the net earnings of the Federal Reserve Banks under the pretense of franchise tax. So that goes the obligation to the franchise that we were talking about before, right? Legalize and extend the float on the debts by reducing the backing or reserve requirements to 40% of the notes in circulation and transactions accounts under Section 11. What that meant was that they were reducing the reserve requirements for gold and silver backing the notes. That is also known as the Bretton Woods Agreement, where they reduced the reserve to 40%, which means now the gold and silver certificates were only backed 40% by gold or silver, right? Authorize hypothecation of obligations, including United States bonds or other securities, which Federal Reserve Banks are authorized to hold under Section 14. Now, what that did, it allowed them to create these instruments and these bonds against chattel, against your pledges. So this was created so that they can have a lawful pretense or legal pretense for what they're doing. You know, establish branches in foreign countries or dependencies of the United States for furtherance of the foreign commerce of the United States under Section 25. This is how the states became federal enclaves, because the states became debtors after the Civil War. They lost their sovereignty, and so they became dependencies of the United States. It goes back to the martial law we were talking about. So when one wants to talk about status and standing and understand commerce and understand how to get your remedy in commerce, you have to understand how the system came into play. So unless you get that this whole thing has been a plan that they created to legalize one, creating a fiat currency, remove us off the gold standard slowly but surely. With the Bretton Woods Agreement in 1940, it was reduced to 40%, and in 1971, Nixon took us completely off the gold and silver standard, right? Now they legalize hypothecation and securitization, and they established the Federal Reserve Bank, which removes the printing and money making from the Treasury now to banks and the Federal Reserve.
Hey,
right?
This is Tyler. I have a question.
Yes.
Scroll up just a tad, just like a few lines. Yeah. Legalizing extended float in the debts by reducing the backing and reserve requirements to 40%. Just kind of like on a related, but on a little bit on a different tangent for maybe a future date. But What is the reserve requirement in the U.S. today for these banks?
It fluctuates. With the Basel IV, it just went up, but typically it's usually about 10%. Banks are only required to keep 10% of customer deposits on reserve. And most of the time, they don't even keep that. They have to borrow from the Federal Reserve through overnight purchase or repurchase agreements to meet their reserve requirements at the end of the day.
A lot of people are really concerned because, and a lot of people who have like business banking with Chase and things like that, like you and I and many of our clients and stuff have gotten letters from Chase saying, hey, you can't take out more than like $5,000 deposit a day, or I think it was even less, like $2,000 or something like that. It's kind of scary that people or businesses in the U.S. can have money in a bank account and they're not able to deposit. There's a withdrawal limit, a daily withdrawal limit, and I think Chase is the most strictest because they sent out those letters like a year and a half ago to all business banking customers. And so the thing is that they don't want to do banking in the United States anymore because of that, as well as you and I both know there's jurisdictional and tax higher tax implications and things like that. So at a later date, because I know you are the expert, at a later date will our students be able to learn what their options are for banking internationally, where the reserve requirements are much higher, there's no withdrawal limits, and they can feel safer about having deposits in there and knowing that there's a higher reserve requirement. Like I believe in Belize, there is right now it is 40%. So 40% of what your credits are in your bank, they've actually got on reserves. In the U.S., it's only 10%. So all these banks failing in the last few years, since 2008-9, all these things happening internationally, I think that people need to look at, banking out of the United States. Would you agree?
Yeah, definitely. And also, if you don't have the opportunity or the resources to bank outside the United States, my suggestion would be to look into your community banks, your credit unions. They operate on different standards, even though some of them are part of the Federal Reserve System. But some of they have much better financial ratios. They don't get involved in the securitizations. They don't, and most of them just do community-based lending. They're what's called a portfolio bank. A portfolio bank is a bank that keeps all its loans on its books. They don't securitize or sell them off to third parties, which means that they know their borrowers, there's sufficient collateral backing those loans, and those banks are much more solvent, right? So I want to touch on the issues with the banks now and why people are not able to get the money out of the bank. There was a G20 summit that the United States was a party to, and now the U.S. has joined the international bail-in regime, right? In its simplest term, bailing is the inverse policy of what was done under the Glass-Steagall Act and the 1933 Banking Act. Under bail-in, the bank survives, the depositors do not. So what they've done is they converted your deposit and into a loan to the bank and made you a creditor of the bank. And what does that mean, right? That means that the statutory bail-in powers is intended to achieve a prompt recapitalization and restructuring of the distressed institution. In the case of resolving a distressed globally active financial institution, bank creditors, specifically those whose assets exceed the FDIC insurance cap, will be subject to expropriation, which basically means that the banks can convert your deposit into an IOU and use that for recapitalization. So this is not normal bankruptcy. Accounts and assets are seized and are converted to stock under the resolution authority. The institution is prevented from failing. Values of securities are not written down through sale on the open market, and this is done to guarantee the continued operation of the financial institution and the stability of the financial system. So what they're saying is the banks can play games and play like a casino and have this derivative house of cards that is ready to crumble at any point, and your deposits are to bail them out. And so a lot of people don't realize that trillions and trillions of dollars were given to the banks by the Federal Reserve already to bail them out in 2008 after the Lehman crash, right? And now they've also bailed out a lot of European banks, but now they've taken it one step further, and they've done this in Cyprus. They've done this in Greece already. They've taken as much as 20 to 40% of customer deposits already. So yes, if you have business banking and you have large accounts, you're going to want to find a way to transfer your money out of it. And you're not going to be able to just take it out. What you have to do is structure a transaction between companies or something and make it a transaction to actually get that money removed, because if you're in any of the top 25 banks, they're all subject to that. Any of these multinationals or international banks, Bank of America, Chase, HSBC, and based on the new Basel requirements, Basel IV requirements, none of these banks would pass the stress test. You know, they have these tests that the international community has set for banking and financial institutions, which has to do with ratios like capital ratios, liquidity ratios, loan-to-asset ratios, etc., that these banks would fail miserably if they were to put to the test. So these banks are insolvent. This financial system is on the brink of collapse, and people have to protect themselves.
I remember that my parents were trying to get money out of Chase Bank and like transfer it somewhere else or put it in some other savings account or some other CD or just hang on to the cash or whatever they were doing. It was kind of a while back, but they had the hardest time in the world trying to get their money out of Chase. They wouldn't cooperate with them. They were giving them the runaround and not letting them withdraw their money.
Yeah, that's why you got to set up as a transaction. That's why what I would do is set up an international IBC or a company and set it up as a transaction, like a sale or something of goods or services, so that it's a transaction as opposed to withdrawal or transfer, or just between a trust and a company, or between a company or something you're doing business with. Or
in other words, you got one company or personal account and another company or personal account that you're involved with, and you basically charge the credit card from your one company as a customer or your one personal account as a customer buying consulting or something from the other company, and you just doing a transaction on the debit. Yeah. You're doing a transaction on the debit card to get all your money out of there, and they can't stop that as long as it's a transaction, right?
Yeah, the transaction may be too big for the debit card, and you may even do a series of transactions. Or if you have like a 401k or an IRA that you're afraid, what you can do is and if you have savings that you're afraid of losing its value, you can actually buy silver or gold and keep it on account, or hold it in depository, and you can hold your savings that way. And a lot of these depositories are insured, and there's definitely offshore depositories that you can have as much safety and security as actually more than having it in your own safe at home. Because they're insured against theft. There's a few dealers and suppliers like the Perf Mint and some other suppliers in the Good Delivery Network that you can use to buy actual silver or gold, and that's a transaction. That way it doesn't raise a red flag.
Right, right. So you're buying, right. So if you got a lot of money in a savings account in the U.S. and you're scared about losing it or not being able to take out of it,
or even a devaluation of the dollar.
Right, right. The devaluation of the dollar, all sorts of stuff, bank failing, whatever. You can make a purchase of offshore gold and storage and silver storage that's insured against everything, basically. So if
against theft, it's usually insured against theft. It's insured against damage. It's insured against government actions like geopolitical actions. And force majeure is the only thing that is not like some catastrophe or something like like
if a comet, right? So if a comet, exactly, comes and hits directly on the storage and blows it up, that would be the only way you would lose out.
Yeah. And then what happens is they issue what's called a safekeeping receipt, or SKR, and that is a negotiable instrument. That's fungible, meaning that let's say you want to have some liquidity, you can actually borrow against that. It could be a secured loan against. It can act as collateral for a home purchase, for buying property or land. for other things as well, for investments. And so there's a lot of options, but the key is understanding who you are and the system that we're in, right? Once you understand and know your status, know that you're not a 14th Amendment citizen, know that you're a sovereign, and know that you are someone who is competent in commerce and learned in the law, then every contract you enter into, you will not only reserve your rights, but you will administer that contract to your benefit. And that's what we're attempting to do here, is to give you a perspective to help you understand a little bit about the history, but understand that this didn't happen overnight, and that everything they're doing, there is a legal basis for it, and as long as you give your consent, it's not unlawful. Now, it was not informed consent. Now, under the UCC, which governs all commercial transactions in the United States, right, and all has been adopted by all the states, it says that negotiation is effective even with an infant, even with fraud, right? So that doesn't mean you don't have a remedy, but that means that it was effective, right? So someone who didn't have any knowledge, and your mother acted as an informant and filled out the application for the birth certificate, even though you were an infant and uninformed at that time, that negotiation was still effective, right? So it's up to you, which many of you have done through the SPC process, to withdraw from that contract and to claim your remedy, right? But the point is, what other contracts of adhesions you have out there that you unknowingly put yourself into that is causing you harm, right? So, well, I brought up the SS5 application, and we didn't go over it. Hold on. Let me, SS5 application. I'll show you an example of how they trap you with these adhesion contracts. And by the way, all this information, everyone who signed up for the webinar and is on, we can if your email addresses are there, we can email you this document that has all this information and these links, if anyone is interested. Okay, there. So, can everyone see my screen, right?
By the way, I just want to mention now there's 66 people on the webinar because I sent out an email to the entire list because we had a low attendee count for the paid subscribers. So if you got the email, impromptu secret webinar, late, just a little while ago, this will be recorded, and the stuff that you guys missed in the beginning will be posted. But this is just kind of a sneak peek of what we go over in the status correction course. If you're not a contributor for the tuition to support our full-time efforts, what we do here, you're just getting a little sneak peek, and we do this sometimes when we're in the flow. We do this every single week. Sometimes we do it twice a month, but we're committed to, really giving people, step-by-step understanding, explanation, articulation, as well as looking at exact forms and how some people fill out different forms to do different things. So if you're hopping on and this is your first status correction webinar, we welcome you. Make sure to get a hold of us if you're interested in getting on every week. And I'm going to hand it back over to you, my friend. We got 66 people on the line.
All right, thank you. Appreciate it. There's a few questions regarding the documents, and people are asking about what's their remedy and how to get out of it, rescissions. This is just, like Tyler said, it's a preview and it's a teaser. We're going to be doing a series over the next 5 weeks, and we're going to be giving you specific remedies for each of these contracts. I'm very big on processes. I'm not big on templates. I prefer to give people the tools and knowledge so that they can create their own documents, and so that they understand and they know what they're creating. We will give you we will give you a basis to go on, but by the time these 5 weeks are over, you guys will be competent and be learned enough to create your own remedy. And that is the goal, for people to be competent in commerce. Does that make sense?
Yeah, because
so
this is Tyler. A lot of people I experience, get stuff and they copy stuff and they pass around stuff, and then when they have a situation that's not working, they ask me to look at it, and I say, well, send me what you got. I say, well, why'd you fill this out like this? This doesn't make any sense. And then people say, well, so-and-so told me to do it. What do you think about that?
Yeah, I find that quite a bit. And in the beginning, when I first came across this information, I was doing documents and filling out paperwork, just doing templates, and really didn't understand what I was actually doing. And I got myself into some situations, because I was mixing jurisdictions. I was contradicting myself, and I was actually putting myself deeper into contract or into liability. So what we want to do is we want to avoid all that. We want to give you a proper understanding, a proper frame of mind, so that you not only do you know how to enter into contracts, but the contracts that you're currently into, how to reserve your rights and how to either get out of them or adjust the terms of the contract so that it's not a detriment or even a benefit to you. All right? Like, for instance, with the Social Security Administration application for a Social Security card, which is the SS5, right? There's a few things here. Here where it says Section 5, where it says citizenship, right? Many people would just unknowingly click either U.S. citizen or legal alien allowed to work or legal alien not allowed to work, right? But these are statutory definitions, or these are civil statuses or legal statuses at law, right? So a U.S. citizen is not a natural born citizen of the state in which they reside or was born in, nor is it an American national who has claimed allegiance to the United States of America. This is a legal classification, right? One of the examples of what you can do is click other and then put either this a citizen or national of the state that you were born in, or you could put American national, which takes you outside of the 14th Amendment status. Also ethnicity and race. Each of these, Native Hawaiian, Alaska Native, Asian, American Indian, Black, African American, other Pacific Islander, or white, specifically Black, African American, and white, these are legal classifications. It does not mean a white person or someone of European descent. Black or African American does not mean someone who is from the continent of Africa. And as far as I know, there's no continent or no country named Black, so I don't know where those will come from. But these are all legal classifications. I want to stress that. So when you click this, it's no different from corporation, limited liability company, or partnership.
Right. It's your option. You could pick any one that you want, in a sense.
It doesn't make a difference, right? And so,
even if, so hold on. You're telling me, in a sense, and again, we're not giving legal advice here, and we don't recommend people just take what I'm going to suggest and run with it yet too early. But you're going to suggest that if someone is dark-skinned and would be, in the layman's terms, called a Black or an African American, can understand enough about the history and what you went over before about how white people that were free landowners had rights under the common law, and that was respected by the corporation, and blacks and everyone else didn't. You're saying that no matter what your skin tone is, you could actually check off white?
Yeah, because under the law, it's all. Not under the law, but under the corporate codes, these are all legal classifications. And so when you click white, it's just similar to a type of corporation or a type of entity. It just classifies you under what benefits and privileges and duties are going to be imposed on you, right? Because under the Civil Rights Act and other acts, there are certain duties and obligations and adhesions that come with being, let's say, an American Indian. So if you choose American Indian, it's a legal classification, and now you're administered under the Bureau of Indian Affairs, right?
Wow.
And so if you're black, if you choose black African American, it just means that you have certain benefits and privileges under the Civil Rights Act or the Equal Opportunities Act and things like that. It's just a legal classification. It has nothing to do with nationality. It has nothing to do with ethnicity, right? So I just want to be clear on that.
Yeah. So people need to just look at it and understand that it's not the layman terms, but these people on our course are reading about this stuff all the time. They're reading cooperative federalism. They're reading stuff on trust. They're watching YouTube videos. They're reading material. They're getting books. They're reading legal dictionaries. When and if, in a hypothetical scenario, someone were to fill a form like this, they're going to be understanding, more the legal classification, not just blindly like, when someone is younger and they fill this out for the first time, they just check off U.S. citizen. They don't know that they're opting into the legislative jurisdiction of the District of Columbia, which is very, very limited, and you just got to read cooperative federalism and other stuff like that to really get a deep level of understanding about that. But it's a very limited jurisdiction.
I'll give you perfect. I agree with you, and I give you a perfect example, right? If I am from South Africa of European descent, I can come to America and claim benefits as an African American. So even Africans don't consider themselves quote-unquote Africans. For instance, if someone is from Nigeria, they consider themselves Nigerian. If someone is from South African, they consider themselves South Africans or Afrikaan, right? And so if someone is from Ukraine, they consider themselves Ukrainian. If someone is from Haiti, they consider themselves Haitian. Those are ethnicities. These are legal classifications. There's no country called white. There's no nationality called white. These are not national. So this is what I mean by denationalization, right? You give up your nationality for a legal classification in return for benefits and privileges. Now, I'm not saying this to indict you or to make you feel bad, because I went through it as well, but the thing is, they make it very difficult to operate without it, On
that point, one of the most common questions we get is people that are working a job, people that are employee, they're not competent enough, or they haven't taken the jump yet to start their own businesses, or maybe they have and they kind of went back into the job market, into the job world. So we have a lot of people that ask us like, hey, what do I do with my job? What do I do with my employer and stuff like that? And some people think that just by using a Social Security number, you're completely a slave, you're completely a 14th Amendment citizen, this and that. Are you saying that that's not the case, that people can actually either apply for one, use one on a job, and still be treated as American nationals, still be treated as a non-resident alien, and so on and so forth? They just need the number to work, quote, in the United States, but they're not necessarily a U.S. citizen. They can under Section 5, they could check off other, and they can write in non-resident alien, and they can check off whatever they want on race and so on and so forth, and they can make this a application that doesn't give up their rights in a way that most people that contact me think that they're giving up their rights just by having a Social Security number.
Yeah, that's true, because a lot of people think the adhesion, or not the adhesion, but the slavery comes from the Social Security number. No, the Social Security number is an identification number. It's an accounting number. It actually proves that you are a creditor of the United States, because if you sign up for, by applying for it, and you sign up for Social Security benefits, it's actually, the government actually owes you, right? It's a trust that's created. Now, what happens is, once the birth certificate has been issued, or even if the birth certificate has not been issued and you're born in wedlock from parents who have applied for a marriage license, which makes the state a third party in that union or that merger of two entities, they become the benefactor or beneficiary of any chattel or property derived out of that marriage, including the children, right? But the way to apply for this, if you are applying for record-keeping purposes or to do business or to get or for any other reason, you would, yes, check other. You can put foreign, you can put American national. Under race, you would select none or other, and you would put your nationality. For instance, if you were born in the Republic of the state of New York, you can put New York native or New York national, right? That is your nationality, right? Or if you were born in another country, you can put that other country.
And
right?
Because some of the states sound the same as the franchise of the corporation out of D.C., I like to put in parentheses EST period April 20th, 1777, because that's when the original jurisdiction republic at common law, state of New York, was created based on the original Constitution. So if you do a bit of research, anytime you put, in California, it's easy because it's called the California Republic, and the franchise is called State of California. But in New York, the Republic is actually called State of New York. So it kind of looks like a franchise because it's got the word state of in there. However, you can make clear which one you're choosing by putting in parentheses, State of New York, parentheses, April 20th, 1777, or EST, established, or you can write out the word established or created April 20th, 1777. And you could find that out just by doing a Google search and doing some basic research on when the state constitutions, because there's two of them, the original one, and you can read it and make sure it's the one that makes references to the common law, because I remember reading that, and I read it again a few months back, and I printed it out, and I circled the word common law like 9 times in the Constitution of the State of New York.
Yeah. Someone's asking about what's the difference between American national, what exactly is defining oneself as an American national. Under Title 11 of the U.S. Code, which is the nationalization code, let's bring it up.
Oh. By the way, there's like 77 people on the call now, so we got quite a sizable group right now, so a lot of people are taking this all in. This will be recorded for people to go over a second time. I know it's a lot of, cutting edge thought processes. You might be exercising your brain like superpower right now. You might need to sleep for like 10 hours after this webinar because it's crazy stuff for most people to take in.
Okay.
I think the franchise of New York, is it just called New York State?
I think it's the state of New York.
I think they go back and forth both times. They can call it State of New York or New York State, because I've seen them both when you go into the courts and get letters from them. They do both, so they can kind of flip flop on you, and they both mean the same,
Okay, so yeah, forgive me. It's Title 8, not Title 11. Nationality, right? It's Title 8, Section 11. Okay.
Can you pop up that form one more time, the SS form? Just on a real tangent, before I lose my train of thought. So people that are doing discharging of debt with the Social Security number that are not getting any success, do you think that could be, scroll up to the top a little bit, please? Do you think that's because when they applied for the social, and I know you can reapply and get up to 10 cards in your lifetime, but the card that they're using, the numbers on the front, the numbers on the back, whatever they're doing, and we're not recommending people do anything, but we are just reporting on, there's a lot of people that email us that are trying stuff and it's not working. Do you think that filling out citizenship, checking off U.S. citizen, filling out race, checking black, African American, or something else on there might influence whether or not you can actually, use those numbers, and when you actually send those documents or instruments in, they look you up and they say, we're not going to discharge or set off this debt. This guy's a U.S. citizen.
Yeah, that could be one of the reasons. Also, it's how you fill it out. Like, for instance, let's say you are filling it out for the registered person or the juristic person, the straw man, right? And you sign it as trustee or as executor. Now you've put a distinction between yourself and the legal entity, right? So now I wouldn't put trustee. I would either put grantor. I would put executor. So now now you've corrected your status in terms of with the SSA administration in terms of who you are and your ability to administer the account. Now anyone who's coming in and attempting to administer that account is acting as executor de santort, or an executor in his own wrong, right? And so if you have already filled out an SS5 and you want to do a correction, one of the things you may want to consider is if you are filling it out for the strawman, I would still leave these areas blank or put in none or put in nationality, but and definitely not use U.S. citizenship. But I would also sign as sign as the executor or a grantor to show that you are not the trustee, you are not surety, and you're not an accommodation. You're not an accommodation party.
Right, because most people just check off self because they think that they're the name in box 18. People probably the first time they filled it out, they checked off self. Unless their parents filled it out for them when they were very little, then they might have checked off natural parent or adoptive parent, legal guardian. So make sure to check, in that hypothetical example, one would check off other and write in their capacity as trustee, executor, grantor, whatever.
Also the address also puts you in a federal zone. So if you are filling it out as a man or woman who has a nationality, I would either cross out male and put man, and female and put woman, because male and female are genders for cattle, right? For
Wow.
You understand?
Wow.
For cattle.
Wow, man. I mean, that's pretty deep, dude. I mean, you're right. Everything that you put on there puts you in a different status, and again, we can't. Hopefully, going over these things a few times and going over the laws and the stuff, I'm really appreciative that you pulled up the codes there and you went over all that stuff in the beginning, that you spent a lot of time preparing. I know you've been preparing this for weeks and weeks and weeks on end for us, but I think that once people see a couple of forms, hypothetical filling out of forms like this 2, 3, 4 times, they'll start to get it. They'll start to know, on their own, how other forms would be filled out, maintaining their American nationality status. I mean, because you see it enough times, there's only enough things that they can put on these forms. There's 1,000 different government forms, but there's only gender, male, female, status as citizen or alien or whatever, an address, place of birth. There's only a few things on all the forms. So once you kind of get all the different criteria and the different ways that the address with the zip code or the abbreviated ZATE puts you in the federal jurisdiction as per the Buck Act and the Trading with the Enemies Act, etc. As long as you get that, you know how to fill that out going forward on any form. As long as you know how to sign in the capacity by : so-and-so, comma, executor, comma, trustee, comma, grantor, comma, whatever. As long as eventually when you get these things and the repetition of 2, 3, 4 of these different forms with enough of the history and the laws and stuff, you start to become competent on your own. You don't need people to show you how to fill out forms. That's the goal, is it not?
Yeah, that is definitely the goal. Like, for instance, with the address, right? The way you write your address can put you in a zone, right? For instance, let's say you have a post office box, right? Usually people will put P.O. Box. Can people see what I'm typing?
Yes, they can, yeah.
Okay. Let's say you put P.O. Box 100, New York, and you put, let's say, 1001, right? So this is the zip code puts you, and what they'll do is they'll add like 7896. This comes right to your door, right? That brings the federal zone right to your door, right? In this case, with the PO box, most post offices are federally owned. There's the UPU, which is the Universal Postal Union, right? Which is an international treaty, international organization, which is de jure, and there's the United States Postal Service. And so you'll find this in many post offices where you get a P.O. box, they'll give you a street address for receiving your mail, right? But what happens is anything that comes general post will have a separate address, and it'll have a separate four-digit identifier, usually 9998, which is private. So, and usually it'll be something like, for instance, one of the major post offices in New York is, I forgot. Here, there's one here, 270 East 70th Street, number 217, right? Postal box, let's say 100, right? And you put New York County, because putting the city and state is a corporate, right? So the county is de jure, right? County, and you can put in the zip. Well, like that. So that is a location. That's a post location. And if you want, you could add general post to just show it's private. But there's you see the difference between this post location and the mailing address?
It's much different.
Yeah.
And a lot of people are just throwing 9998 on the end just because they picked up that little nugget of information. That's not correct, is it? If you're going to, you're saying that these general posts, look, there are some post offices that are de jure and corporate that actually have, if you look it up on the Postal Service's website or whatever, their actual last 4 digits of that 9-digit postal address actually is ending in 9998. In other words, what I'm saying is you don't just take your existing zip code that is, 11111-23456 and just ignore that the last 4 digits are 23456 and you decide to put 9998 on there incorrectly. That's not correct. It actually has to be ending in 9998. Naturally, you can't just lie and throw that on there.
It has to be a general post, and a lot of people, there's some gurus out there that have been telling people you can change your house to general post. That is not correct. What happened was, before the states gave up their sovereignty, people actually had allodial absolute title to their homes, and they actually owned private land, and that was private, right? But now all property is held in trusteeship by the county, and the county is the trustee, but it's all held by the government, and so there's really no such thing as private land anymore. So your land is not private, so you just can't make it general post, right? And you have to have a post office that's general post, and it will say so, like Tyler said. If you go to the website and you look up the post office's address, it will tell you if it's general post or not. And then that's not the only thing. If you're going to establish a post office box there, once again, that's a contract, right? Because you see, anytime there's, it's not only a contract, adhesion contract, but it's a security agreement. Whenever you are entering into an agreement with someone and you're the only one signing, that's an instrument. That is a note, that is a bond, that is an instrument, and I promise you it'll be securitized, right? Because usually whenever there's agreement, there's two parties, there's a mutual assent, and it is mutual agreement by the parties. There's a meeting of the minds. That is one of the elements, 6 elements of a contract. A mortgage note application where you're signing and they're not promising anything, that's an instrument. That's a security. That's a pledge, because you're pledging to pay for this, and they don't have anything that they're pledging or they're offering in return, right? So and there's no, they don't sign the contract, right? So this is a security agreement, right? And so you want to know that going in. And so what you have to do is you go there, and you have to set it up correctly. And if you go there and show government ID, government issue ID showing that you're a government employee, then guess what? You're going to be categorized as a government employee. And what you would have to do is go, what I recommend doing if you want to change it to general post is you can go online and do a change of address and actually change the postal box to general post. So you just can't set up a PO box and make it general post. So we'll show you guys some of the processes and how to do that. But these are all the ways that they operate off the presumption and assumption that they're dealing with 14th Amendment citizens, they're dealing with debtors, and they're dealing with people that are incompetent. And the executive office is vacant, so they have to administer the estate. That's how the constructive trust is created, right? And that's why when you go in and you don't handle the affairs of the trust because they designated you as the trustee, you are administered and you are punished or you held in contempt. Does that make sense to everyone? Let's see.
So it'd be a good idea to get a World Service.
We have quite a few.
Yeah, it'd be a good idea to get World Service Authority passport as an ID, or an affidavit of identification, or something other than government-issued ID if you're trying to phase out those contracts or amend your applications and change the status on it.
Yeah, well, what qualifies as a government-issued ID, right? Something that is certified or authenticated by a government official, right? So if someone were to create an affidavit of identity and it has all the elements of a valid ID, it has an identification number, it has a date, expiration date, shows name, address, date of birth, and hopefully a picture. If you were to get that affidavit notarized and authenticated on the state level, that is considered a state authenticated document. Now, if you want to get it authenticated on the federal level, you can send it to the Department of State and get it authenticated on the federal level. So you can create your own affidavit of identity that is quote-unquote government authenticated or government certificated. That doesn't put you as a 14th Amendment subject citizen or corporate employee, federal employee. Does that make sense?
Yeah.
People are asking questions like, how can I fund my trust account?
The status correction members that are in that course or have been in that course the last several months we've been doing what we've been doing, they do have access to a sample affidavit of ID. It is the one that you prepared and has all the elements and that you've used to get P.O. boxes, general post boxes, several other things. So it's got all the elements on there, and if they go and, like you said, authenticate it, then that's even better because no one can quite. It's got all the elements that they're looking for government ID. So it'll work in lieu of government ID for opening up bank accounts, post office boxes, and etc. most of the time, unless you get a real thick-headed robot employee there that maybe tells you no. But generally, more than half the time, you should work with a little bit of persistence, negotiation, and being polite but persistent. Correct?
Yeah, exactly. And you have to know who you are. That's why you know your status. Because if you know who you are and you conduct yourself such, then they'll know that you're not just one of the American sheeple who are just going to lay down and do as they're told. So I'm looking for, because I want to go back and answer that question on nationality.
It makes sense. Listen, if you're born in America, and then you decide to go to France and live in France, they're not going to deny you getting a post office box or doing a bunch of different things just because you're a foreigner. So
exactly.
Yeah. So people can go over the world and go to different countries and be foreigners and get driver's licenses and work, get whatever government ID number. Like I guess if you go to Germany or Italy, or I guess they have some version of a social security number that they want you to apply for to have a number to work there too. But you can apply for it. You're not going to be a bozo and check off German citizen. You're not going to be a bozo and check off Italian citizen if you're from America. You're going to be filling out the form through the filter of knowing who you are. I'm from America. I lived in America my whole life. I'm just going to be living in France for a little while, working here for the summer, or going to college here, or whatever. You're not going to check off that you're a French citizen because you're not.
All right. Now, according to 8 USC, Section 1401 U.S. Code, right? And remember, this is just code here, right? But this is to answer the person's question in terms of what's the difference between a national and a citizen, right? The following shall be nationals and citizens of the United States at birth. A person born in the United States and subject to the jurisdiction thereof, right? So what is the United States? Is it the 10-mile square radius of the District of Columbia? Or is it the territories, the insular possessions, the enclaves? So what is the United States? You understand? So a person, and what is the person? So when someone, when you go into court or whenever you're dealing with one of these government agencies, right? One, they're assuming that you're a person as defined under the statutes and codes, right? And they're assuming that you are a United States citizen and subject to the jurisdiction thereof. So it's up to you to rebut that presumption, which a lot of you have done with that SVC correction, right?
Right.
Status correction and SVC process. So, and a person born in the United States to a member of any Indian, Eskimo, Aleutian, or other Aboriginal tribe, provided that the granting of citizenship under this subsection shall not in any manner impair otherwise affect the right of such person to tribal or other property. A person born outside the United States in its outlying possessions of parents both of whom are citizens of the United States and one of whom has had a residence in the U.S., right? So that is how they define a national. So all U.S. citizens are nationals, but not all nationals are U.S. citizens, right? So, for instance, let's say someone is born in Puerto Rico. They're considered a U.S. national, but they're not U.S. citizens. Right? You know, people born in Guam and Samoa and some of these other insular possessions are considered nationals, and if they're given like a passport or something, it says like they're not allowed to vote or whatever. It says national. It signifies that there's a limitation there, right? So to speak. So that's under 8 U.S.C. Section 14, right? Nationals and citizens at birth.
You know, it's crazy, and people need to realize, I mean, let's say you're in Colorado or Washington State or one of these states that's legal, or Alaska, one of these states that's legalized marijuana for recreational use. If you're in a national park, if you're in a federal territory, a national park, or a U.S. military base, or some other federal territory within, you know, an enclave within the big-ass, you know, geographic external boundaries of Colorado or Alaska, it's not legal to recreationally use marijuana. They can arrest you there, correct?
Yeah, if you fall under the codes and statutes, right? A lot of people don't realize that most of this war on crime and drugs are done under prima facie law. I brought this up in here. I want to go over that real quick. That people don't understand that there are when you go into court and you plead and you guilty or not guilty. Not only are you pleading to the charges, but you're also agreeing and to be administered under the code because you have to agree to it. So I want to go over here under the definitions. Prima facie law, right? Okay. Prima facie law is a code or statute codified as prima facie evidence of the statutory law, but has not yet been enacted as positive law. Positive law is described as the law which applies at a certain time, past or present, at a certain place, consisting of statutory law and case law as far as it is binding. More specifically, positive law may be characterized as law actually and specifically enacted or adopted by proper authority for the government of an organized juror society. All right? So here we have the definition of positive law. A system of law promulgated and implemented within a particular political community by political superiors as distinct from moral law or law existing in an ideal community or in some non-political community. Positive law typically consists of enacted law, the codes, statutes, and regulations that are applied and enforced in the courts. The term derives from the medieval use of positum, Latin, which means established, so that the phrase positive law literally means law established by human authority, also termed jus positivum, made law. So the laws now, all the codes and statutes are written by the Office of the Law Revision Council, right? According to Wikipedia, the Law Revision Council prepares and publishes the United States Code, which is a consolidation and codification by subject matter of the general and permanent statutes of the United States. It's a group of lawyers that Congress has contracted to write codes and statutes. So all the shows they show you of them spending all the time in the office overnight and working on drafting a bill is BS. They don't write any bills, all right? The Office of Law Revision Council writes all the laws and draft it. And I'm going to take you to their website, and on the website it says itself that it's not positive law. It's prima facie, which means that it has not been confirmed by any Supreme Court or any judge to be either constitutional or positive law, which means that the only way you can be held accountable to it is if you agree to it by tacit acquiescence or by written confirmation. So let's go to their website. What do you think about that, Tyler?
It's good material. I'm just reading through a list of these 89 questions that people have. I don't think it would be very helpful for you to answer all these questions. I think
a lot of them are off topic. Yeah.
Yeah, a lot of them are people just asking for a shortcut. Tell me what to do. You know, how do I fund a bank with promissory notes? How do I fill this form out? Whatever. People need to take a few steps back, go back to school. It's kind of like, listen, you're not ready to do open heart surgery yet. You didn't even finish biology class. You didn't even finish high school biology and chemistry class. You didn't even apply to go to undergraduate college, let alone graduate that and then go to medical school, let alone, you know, do your residency, do your on-site training where you watch other people do open heart surgery before you do it with trained professionals sitting there right next to you, you know, looking right into the patient's body being cut open. You guys need to take a step back and not ask, how do I do this?
But I will answer one question in regards to using instruments and bonds and notes. Anyone that wants to get involved in private banking, that wants to be able to monetize or issue instruments backed by some kind of collateral, right? People always try to quote SJR 192 or Public Law 4110 and say that we have a right to issue bonds and notes. You have the absolute right to contract. However, if you want to be recognized or be able to enter into the public, which means take your private instruments and conduct commerce in the public, you need to have a financial intermediary. You need to be able to have your own or work through a financial intermediary, which would, if you think that what you've been studying so far is very difficult and complicated, let me tell you this. What's involved with interfacing with the banking system, with the financial intermediary system, with SWIFT, with all these different intermediaries, the Federal Reserve open market window, the clearing systems, you are nowhere near ready or competent to deal with that. Even to try to upload and post instruments or securities on the DTC, a lot of people want to know about that. I'm going to tell you something. If you don't know what you're doing, you are going to get your ass handed to you. And you will get a call from federal agents. Okay? So, like Tyler said, you have to walk before you can crawl. Believe me, once you are competent in commerce, once you're competent in commerce and you understand how to contract, you will have no problem creating value in the world. And two, you will have no problem attracting financial energy. Now, we are working on creating an intermediary for such purposes where people that are confident and have become a holder and holder due course of their estate to be able to transact and handle the affairs of their estate, but no one on this call, including myself, is at that point and ready to do so. So that's all I say on that subject.
Things are being worked on to make things easier, and when people take the patience to learn and understand the material, good things are coming down the line, basically.
Yeah. Okay, here's the website, Office of Law Revision Council, I think. Yep, see, Office of Law Revision Council.
Not to say that you can't get some things done and discharge certain kinds of debts and things like that currently. If you get your basic SPC stuff done, become a holder in due course, there's a small little checkoff list. So I don't mean that to put out there that you can't use any of this stuff. It's just...
Yeah, I mean, no one's saying that you can't discharge debt. Well, when you get into trying to mix public and private, taking private instruments and trying to monetize them in the public for Federal Reserve notes or other fiat currency, then you are in a whole nother ballgame. So it says here the United States Code is a consolidation and codification. Go ahead.
What you can do though is you can sell, and we have
Go ahead.
We have a place where you can sell your private administrative or public judgments and let the banks deal with the monetization themselves. And so you're at an arm's length. You're just selling it to someone else who's already, in the system to monetize it. And we can handle those things for people that have private administrative, affidavits of non-response 2-3 times, notices of default and stuff like that from someone that they're the claimant against some respondent who has injured or damaged them, and you've got this private administrative judgment for several thousand, $100,000 or $1 million, and now you're sitting on it and you don't know what to do with it. Or a public judgment and you're not able to monetize a public judgment because maybe you brought it to the sheriff and or you didn't know to do a writ of execution or whatever, and there's no money available to levy from that entity's bank account or whatever. There is ways to monetize those judgments and cash out on it, and so people can contact us if they're interested or if they're looking for something like that. I'll let you continue.
Okay, so here under their own website, right, within the context of the U.S. Code, the term positive law is used in a more limited sense. A positive law title of the Code is a title that has been enacted as a statute. To enact the title, a positive law codification bill is introduced in Congress. The bill repeals existing laws on a certain subject and restates those laws in a new form, a positive law title of the Code. The titles of the Code have not been enacted through this process are called non-positive law titles. Non-positive law titles of the Code are compilations of statutes. The Office of Law Revision Council is charged with making editorial decisions regarding the selection and arrangement of provisions from statute into the non-positive law titles of the Code. Non-positive law titles as such have not been enacted by Congress, but the laws assembled in the non-positive law titles have been enacted by Congress. So what they're telling you right here is that a lot of these laws in the Code have not been enacted in positive law and they have not been enacted by Congress. So they have no force and effect unless you agree to them. Try and see. So a positive law title of the Code is itself a federal statute. A non-positive law title of the Code is editorial compilation of federal statutes. For example, Title 10, Armed Forces, is a positive law title because the title itself has been enacted by Congress. And when they say enacted by Congress, meaning that it has an enacting clause and it has been gets its authority from the Constitution for the United States of America and is not in contradiction of it, which means that a Supreme Court would uphold it as constitutional. That is something that people need to understand, that a lot of these codes and victimless crimes that they're being administered under is not positive law. And so when that goes into status and standing. So when someone is bringing a claim against you, when the state is trying to bring a claim against you for, let's say, running a stop sign or driving without a license or something like that, they are administering code that you've agreed in one way or another to be bound by signing the driver's license application or something like that. So that's what we mean by understanding your status and standing. Because someone who has a proper status cannot be held accountable to these codes, because these codes only, the only people subject to these codes are 14th Amendment subject citizens that we mentioned before. Does that make sense to everyone?
So the remedy for that would be you could, instead of what people have been taught by some stuff that I've observed not working all the time, not working too well, with people trying to set off with bonds or sending stuff to the Treasury, try to set off the, quote, criminal charges for a traffic case or a more serious case. An alternative way would be to put the burden of proof on the state to prove that that code is positive law, and if they can't prove it, the case must be dismissed, correct? If you know how to motion the court correctly and put that on paper in your pleadings. Is that correct?
Yeah, what you would do is you challenge the statute by doing a certification of statute, and that falls under political question. So the courts will not deal with that. It's non-justicable. So what you do is you subpoena the Attorney General and the clerk of the Supreme Court. Like, for instance, if you are in a criminal case and the DAs are coming after you for charges, then you would do a certification of statutes, and they have to put on the record and certify that the statute is positive law, that it is constitutional. And you can subpoena the clerk of the Supreme Court and have them give the written opinion of the Supreme Court on that law, that it falls within the authority of the state, or it is constitutional, or it is positive law. Because unless you agree to be administered under it, if they can't prove it's positive law, then they can't hold you accountable to it. Does that make sense?
Makes sense to me. You got a lot of material to cover, or a little bit of material to cover?
No, not really. I went through most of the stuff that we went. Political question, right? A question that a court would not consider because it involves the exercise of discretionary power by the executive or legislative branch of government, also termed non-justicable, justiciable. Okay. A CJS constitutional law, section 176. So that's what I meant by political question. So what happens is, if you want to, what you can challenge the court is subject matter jurisdiction or personam jurisdiction if they're trying to administer you under codes and statutes. But if you want to challenge the statute itself, it's a political question, and you have to subpoena the Attorney General, which is an agent of the executive branch. And then, because you're challenging the legality of the law, the lawfulness of it. Yeah.
So this study guide that you've got here, can I ask if, I know you put a lot of time into, copying, pasting, and sorting through and sequencing it correctly so that people have some really concrete stuff here in just 10 pages instead of reading, I've got on my computer, hundreds of pages of stuff, and it's just overwhelming. This is a nice little compact little 10-page good study guide that you spend some time on. Can our students get this?
Yeah. Anyone who's on the webinar that has their email, we can send it out to them.
Why don't I just post it on the website under free documents section? I'll put I'll put study materials from webinars section in like a day or two. I'll post it up, and I'll just embed this right into the page there, if that's okay with you. Yeah,
that's fine. Yeah.
Thank you. Thank you very much.
Yeah, and there's a lot of references in here that people can look up. Like, for instance, the Libra code. It's right here, actually. I have the Libra code right here. This is the Executive Order 100 regarding the suspension of habeas corpus, and it talks about the rules of engagement for martial law, military jurisdiction, and it's very interesting things here. When you go through it, when you take the time to go through it, you can see how they get away with a lot of stuff that they do. Like, for instance, under Article 7, it says martial law extends to property and to persons, whether they are subjects of the enemy or aliens to that government. So when you are being administered as an enemy of the state or alien to that corporate government, that's how they do it. This is what they use as their justification for it. So it says also under Article 10, martial law affects chiefly the police and collection of public revenues and taxes, whether imposed by the expelled government or by the invader, and refers mainly to the support and the efficiency of the Army, its safety, and the safety of its operations. So they'll do whatever measures to ensure and make sure that bureaucracy will stay. And the enemy are the international banksters who run the Federal Reserve. Like, they have co-opted this this nation and this government, and that is the foreign occupation here. So I'll include this as well because this goes into it. So this has 147 articles, but if you go through this, you'll begin to understand how these admiralty courts are administered. So does that make sense?
Yeah, makes sense.
Let me see if there's any more questions. I want to make sure.
Someone said one of the 104 questions. One individual said one of us was rude. He's probably talking about me. I'm trying to make sure you guys. We get calls, we get emails almost every day of people who get themselves into more trouble, and I have to tell them, listen, if I were in your shoes, I would terminate that UCC filing. Don't put a lien on that individual. Don't do that. Don't do that. We got people who get locked up all the time for jumping into this stuff, not knowing what they're doing. So I'm trying to, I love you guys because you're good people. I'm trying to make sure you guys don't F up and wind up in prison by doing stupid stuff you don't know about yet. So if I come off rude, it's from a place of love that I care about you guys, because I've seen people and I've seen friends not only get locked up for stupid stuff that they jumped into too early over, instead of paying a $100 traffic ticket, they wound up going to jail. But some people have even been killed because they didn't know how to be polite to police, or they didn't know, they said the wrong thing, they got tasered, they got beat up in jail. A couple people are even dead. So this stuff is, serious stuff. If you don't know what you're doing, you could.
Yeah, two of our mentors actually have been charged. One of them has been sentenced to 15 years, and the other one is facing a sentence waiting to be sentenced, has been convicted and waiting a sentence. So, and these are people that we highly respect and we learned a lot from. And so this is not something to play with. If you're not ready, if you don't understand this clearly, your best bet is to, if you can afford to, resolve your issues the traditional way until you learn more, then do so. Now, if you can't, there are remedies available to you. One of the remedies available is a lot of people don't realize that the straw man is in a state of bankruptcy, just like the United States is, right? And so one of the remedies available is that the bankruptcy was started in the entity is in trusteeship, but it has never been administered, never been fully completed. So here under now that all lawful money has been removed from circulation, there can be no payment of debts, only novation or discharge. Novation is the act of substituting a new obligation for an old debt that replaces an original party with a new party. Every time someone pays for something with a Federal Reserve note, they have essentially created a novation, and that debt is transferred as an obligation backed by the full faith and credit of the United States. Discharge is any method by which a legal duty is extinguished by any of the following means: payment of a debt or satisfaction of some other obligation, the release of a debtor from monetary obligations upon adjudication of bankruptcy, right? The dismissal of a case, the canceling or vacating of a court order, and the release of a prisoner from confinement. Right, so the juristic person or the strongman that was registered upon the application for one's birth certificate has been declared insolvent and is being administered under involuntary receivership. The only way to enact the proceeding and get complete discharge of any and all debts is to file a bankruptcy proceeding for the strongman in U.S. Bankruptcy Court. All U.S. states have adopted provisions of UCC Article 3, Section 305A of the Uniform Commercial Code, whose provision deals with insolvency proceedings. An authenticated discharge from a federal bankruptcy judge must be honored by all states by operation of law. Congress has abrogated the state's sovereign immunity in bankruptcy proceedings. See Hood versus Tennessee Student Assistance Corporation, 319 Federal 3rd, 755, 2003. Right? States, whether or not they choose to participate in the proceeding, are bound by a bankruptcy court's discharge order no less than other creditors. That's New York versus Irving Trust Company.
So
right?
are you
So
trying to
the fact that under the Organic Act of go ahead.
are you trying to say that this is talking about bankruptcy proceedings? A layman would scroll through this and say, "Oh, okay, well, I'm not going to file bankruptcy, so that doesn't apply to me." Are you saying
Well, you
that?
file bankruptcy for the straw man, right? And many people don't file it correctly. You do a Chapter 7 exempt property discharge, right? Chapter 7. And then what happens, you put all debts under unsecured priority liens. Because you, for instance, let's say you have a foreclosure case going on, right? Many people will put that under secured property, right? Why would you do that? Many times the party attempting to foreclose is not even the holder or the holder in due course of the note. They don't have standing, so why would you put it under secured? Because the first of all, the mortgage does not secure the property. It just puts a cloud on the title. Okay? Because you don't even own the property to pledge it. You have beneficial interest in it because the mortgage is a trust document, right? So secondly, it's unsecured. It's been securitized and it's been sold off to creditors, and the note and the mortgage has been bifurcated. So what you do is when you do that, you put the onus of proof on the creditor who's making a claim to prove that they have standing and they can actually bring a claim in bankruptcy court, right? Same thing with any claim. It could be IRS. You put it under unsecured priority claims. It could be child support, alimony. Those are all accounts that are being administered. They're all commercial claims. Here, I'll give you an example, right? The fact that under the Organic Act of 1871, the United States has been organized and operating as a municipal corporation and partnering with private corporations and trading companies, it loses its sovereign immunity and descends to the level of a mere corporation. This applies to all state franchises that have incorporated as federal enclaves and issued general obligation bonds and trading in trade receivables payables through the court registry investment system. Under the Clearfield Doctrine, it stare decisis upon all courts and imposes that an entity cannot compel performance upon its corporate rules unless it, like any other corporation, is the holder in due course of some contract or commercial agreement between it and the one on whom it demands for performance are made, and is willing to produce said document and to place the same into evidence before trying to enforce its demands. Okay? Furthermore, governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen. Remember what we said before, 14th Amendment citizen can be a corporation or another entity, right? Where private corporate commercial paper, Federal Reserve notes, and securities checks are concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separated from government. Clearfield Trust Company versus the United States. All right.
So now, can I butt in for a sec?
Yeah, go ahead.
Okay, this is Tyler. I read what you said there. Scroll up just a little bit. Those two things about the Clearfield doctrine there. Governments descend to the level of mere corporation, take on the characteristics of mere private citizens, where commercial paper is concerned, blah, blah, blah. Holder in due course of some contract, commercial agreement, and who's demands performance. Okay. So you read stuff like that. But I just want to make it clear to people in case it's not clear that just because you read these things now doesn't mean you can go into court with the utmost of confidence and know that the judges and courts are going to respect this. As somebody said in the chat bar, Ronald says, "You're doing an awesome job, Tyler. These guys wear their feelings." This is in reference to that one little one person said I was coming off rude. Ronald stood to my defense and said, these guys wear their feelings on their shoulders and are offended easily and don't understand that a lot is at stake. They need to grow up and get the info you and your team are putting out that will eventually save them and their family and stop focusing much on the petty stuff. So what? You come off rough, and the judge and administrator will come off rougher. Stop crying, people. So yeah, that's the judge is definitely going to come off rougher than I'm being to you now. It's tough love because when you go in there, you can't just remember that you read the Clearfield Doctrine. First off, you got to put in a pleading. This is the key thing that maybe I want to.
It's not what you say; it's what you can prove. Also, you have to be able to prove. There's a whole process of putting together your package.
You have to prove it through non-response through your pleading, and people don't have any experience in doing pleadings. and they just think that they can go in and say stuff, or they can go in and say I'm a sovereign this, or blah, blah, blah. You have to, like, for example, the pleading that one might do is an order to show cause, for example. Order to show cause, and put that Clearfield doctrine, put some other things in there, and
what you also want to put, I don't mean to cut you off, but what you also want to put into evidence, admit into evidence, is you want to show that that entity, let's say the state is coming after you for charges, right? You want to show that the state is acting as a corporation and partnering with trading partners by issuing general obligation bonds, right? And if you have the wherewithal, every court case, right, every misdemeanor and felony has a CRISP account attached to it and a QSIP number. If you're so inclined to get the QSIP number of that case, you can get a securitization report from the SEC showing that that case is being traded, that it is a commercial transaction.
And because of that, you can import the Clearfield doctrine into your pleading, and the court's going to have to admit it as evidence, because no one's going to put in a verified rebuttal that the government is not trading and engaged in commerce. So now they're, you've taken away their jurisdiction over you, and you're on an equal playing field, and they're not subject to sovereign immunity anymore. But you have to put all this in your pleading and in your motion for an order to show cause, and then followed up by a motion to vacate. There's stuff, in other words, ladies and gentlemen, there's stuff on the private side that you may want to put into the case to do a discharge, to give your private notice, and there's stuff on the public side. You must put pleadings into the public side if you have an animating, open case that's going on. You can't just read this stuff and believe in your head. You have to notify the court to take notice of all these cases like the Clearfield doctrine and like Hale versus Henkel and like et cetera, et cetera, et cetera. And you have to move the court to take notice, to order to show cause, or otherwise the case must be vacated. You must take that evidence of the lack of certification from the Attorney General of the prima facie law and admit it into evidence into the case. If you have no experience doing that stuff, you got to get with Jurisdictionary How to Win in Court, or you got to get on pennfoster.edu and sign up for the paralegal course, or get with someone, get with even a criminal defense attorney or anyone that can give you some basic, basic traditional, rules, federal rules of criminal procedure. Just get some basic procedure in the public side. Otherwise, you're going to be crucified. Right?
Yeah, and we're working on putting together a jurist course to give people a A to Z education on how to navigate the court system and how to work and put in and draft motions from scratch, like understand and how to cite their motions and how to keep their cases and their claims in the common law and not come under prima facie law. So you see, I put in the House of Representatives or U.S. Congress, and you have all these entities that are showing up under DNB, which is Dun & Bradstreet, which is basically a credit reporting agency for entities. So the Congress is trading as a company, as companies on Dun & Bradstreet, right here, as you guys can see. Congress traded as Congress United States, Congress United States. So these are all different files for different trading companies that Congress is trading as. IRS. Look.
So if you have a tort claim against them and they don't pay out on it, I guess you can screw up their credit rating, huh?
Yeah, you can screw up their credit rating. You can find their DUNS number. In some instances, you can get their EIN. But see, look, the IRS is trading as a company.
So saw the main one, 1111 Constitution Ave Northwest on there, but there's a whole bunch of other ones. Why do you think that is?
The main one is here, the Puerto Rico, right?
Mm. Look at that.
Because that's where they're domiciled, right? So it just shows you that we're not dealing with government. We're dealing with a corporation, a bureaucracy that has denationalized the American people, American nationals, into 14th Amendment citizens, and is administering them under code, under prima facie law. And that is the crux of understanding status and standing, because it doesn't matter how many filings you do until you understand and know who you are and understand that you have to rebut presumptions and assumptions in every interaction with the government or one of their agencies, then you are just going to recontract your way back into corporate slavery.
Someone said, Kim says, just because a company is listed in DMB does not mean that they are being publicly traded, only that they are incorporated and have private shares. Would you agree with that clarification or no?
Yeah, when I say trading, I mean trading as or trading with corporate partners. The reason they're on DMB and the reason they have a DUNS number is when they are doing a bond offering, a general obligation bond or a GO bond is how these entities, these municipalities raise revenue for their operations, right? And so when I say they're trading, they're trading with partners. You have 21 basic dealers, basic companies, large companies that have access to the Fed window that buy these bonds directly. Some of them include like the major banks and stuff like JP Morgan and Wells Fargo. That's what I mean by trading. I don't mean trading as a public entity. No, they're not on some exchange. The only ones that are trading as public companies are what's called the GSAs, the government-sponsored agencies like Sallie Mae, Fannie Mae, which is these are that will do the mortgage securitizations and securitizations of the student loans, and that's why everyone that's why I say that whenever you deal with, it doesn't matter what the debt is, even a student loan, it can be discharged in bankruptcy if you understand how to administer or fill out the forms correctly. Because Sallie Mae or SLM Corp is a public corporation. It's not a government entity. So it's just like any other corporation, any corporate debt, a properly discharged bankruptcy proceeding, that debt can be extinguished. No matter what the attorney tells you that you can't discharge student loans, that they tell you can't discharge an IRS debt. They're all commercial claims.
Someone, you got this pulled up here. That's very good elucidation on that. Thank you so much. That's wonderful clarity for our students and myself. Someone asked, Hezekiah asked, with the W-4 form that you're looking at now, which is when you go to get a job, basically this is what your employer makes you fill out, and most people filled it out before they knew enough. Filled it out a certain way, and maybe with new education they realized they filled it out incorrectly. Is there a way, Hezekiah says, to amend or change the information that was entered upon the W-4 form?
Yeah, if you want to, what you do is you go fill out a new one. You fill out a new one and you give it to your HR. And things you may want to consider is, one, you don't claim any exemptions, right? Because that's a benefit, right? Because anything between A through G puts you within their jurisdiction. Because what you're doing is you're asking for a benefit, which is you're agreeing to be a taxpayer, right? There's only one line that you want to be concerned with, and that's H. If you want to maintain your status and standing, right? And that is here where it says number of exemptions, you put 0, and then where it says, where is it? Here, under 7, right? Exempt. It says, I claim exemption from withholding. For 2015, I certified that I meet both of the following conditions for exemptions. Last year, I had a right to a refund of all federal income tax withheld because I had no tax liability, and this year I expect a refund of all federal tax withheld because I expect no tax liability. So meaning that if you are a national or you are foreign to or not a taxpayer as defined by the Title 26, then you are exempt. Under the Constitution, Congress was given the right to levy a direct tax. All right, a direct tax is a tax that affects everyone the same, like a sales tax. It doesn't matter what color you are. It doesn't matter where you live. It doesn't matter how much money you make. The tax affects everyone the same. A gasoline tax affects everyone the same. Those are direct taxes. And an excise tax affects everyone the same. An income tax is for entities, corporations, not the people, right? And so that is how it's a fraud. But you can volunteer. It is a voluntary tax, meaning that if you volunteer for it, you can be held liable for it. So by filling out a W-4 and asking for exemptions and benefits, you are volunteering for it. So what you would do is, one, like I said before, if you want to remove yourself, you don't complete any of these. And under H you put 0 so that the HR doesn't fill that out and put something else in there. And then you put your name and you put your surname or your family name, and you put your common law name. And I wouldn't put a social security number. A lot of people are afraid, or they feel that they won't be hired if they don't provide their social security number, but it's a federal crime to require anyone to give a social security number to offer them employment or services. I forgot off the top of my head what federal code it is, but they can't force you to give your social security. It's not even your social security number, but the social security number that was issued to you. So you can actually leave that blank. And what else? I wouldn't put anything here. I would keep that blank. Once again, you just put exempt, and then you sign it. And what I would do is I would make a copy of it before I give it, so that you always have a copy of it, so that if anything was changed on it, you have the original, a copy of the original. Does that make sense? Can everyone hear me?
Yeah, people are typing in. Great answer. What did someone say? Great answers, bro. Those were my next questions. Perfect. Someone says the company you work for is going to tell you you have to put the social security number. So what do I do?
Okay. Well, most of the time, let me be clear, right? Most of the time, you're going to be dealing with someone in HR who just knows how to shuffle paperwork. They don't understand the law. They just do as they're told, and they will give you a hard time many times. So what I suggest is, one of the things that we're going to offer is, there's actually a letter that you can provide to your HR if they give you a hard time, that they can refer to their legal department and let them handle it. Don't argue with your HR. Don't yell at them, and don't put a UCC filing on them. Okay, that they're just doing their job. They don't know, just like you didn't know, right? It's a legal question. So the person or the department that you actually would bring up issue to would be the legal department. The legal department will know that they are opening themselves up to a lawsuit or discrimination if they try to force you. So there's a way to go about. Remember, we want to stay in honor, right? We don't want to go out there and creating controversy and dissension wherever we go. We don't want to be known as combatants, right? So these documents that we're talking about, I will work with Tyler for getting them on the website. But like I said, I don't like doing templates, because if you don't understand the premise behind it, then you're not going to be able to stand on it. You're not going to be able to enforce it. And when it comes down to addressing it or being questioned about it, you're not going to know what you're talking about. So we prefer to teach you to be competent and have you understand the concepts and the principles, and you can apply it to your specific situation.
Yeah, we appreciate that, Grant. Someone asked a good question. Can we give for employment, can we give in a W-8-BEN?
Yes, you can give a W-8-BEN. You can give an affidavit of identity. Let me bring under the instructions for the W-4. It says that they can't specify what form, or is it the I-9? I think it's for the I-9.
Yeah, I would love for you to pull up the I-9, because some really cool stuff I want to point out.
Instructions. Yeah, they said that they can't specify what form you give. Hold on.
Now, just read the top. All the way at the top, it says discrimination notice. It's the first thing that they see. So that is a real powerful form right there. I would love to read that. Let's see.
Yes.
Anti-discrimination notice. It is illegal to discriminate against any work-authorized individual in hiring, discharge, recruitment, for referral, for a fee, or in the employment eligibility verification process based on the individual's citizenship status, immigration status, or national origin. Employers cannot specify which document or documents they will accept from an employee. The refusal to hire an individual because of the documentation presented has a future expiration date may also constitute illegal discrimination. For more information, call the Office of Special Counsel for Immigration-Related Unfair Employment Practices, OSC, at 1-800 blah blah blah, number for employees, and 1-800 blah blah blah, number for employers. Or visit justice.gov/whatever. What is the purpose of this form? Do we want to read that, or you want to just summarize? What do you want?
Yeah, but so basically, what that's saying is that you can provide any form of identification, and they can't specify what form they'll accept and what they won't accept. And so if you create an affidavit of identity or some tribal identification or something like that, and you provide that, then you've fulfilled your purpose in completing the form.
Right. Now scroll down to the actual form, and it has definitions of non-citizen national of the U.S., a lawful permanent resident, an alien authorized to work. That's all cool stuff. You guys can read that. But scroll down to the form. Oh, you're on the instructions. Is the form there, or you got to pull up the form separately?
Let me see if the form is here. I'm trying to see if there's anything about the Social Security number. Physically, where is it?
The fact that it has options on there, non-resident this, alien that, lawful permanent, you don't need to be a U.S. citizen in order to work. Look, U.S. citizens or nationals, it's got all those options in the instructions here, but can you just Google and put an I-9 form? This is just the instructions.
Here, the form is here.
There you go. Now, this is what I
Here's the form.
wanted to point out. Look at this. Scroll up a little so people can see the header, that this is the form. Yeah, there you go. Employment Eligibility Verification. Department of Homeland Security, U.S. Citizenship and Immigration Services. Start here. Blah, blah, blah. Anti-discrimination notice. It is illegal to discriminate against work-authorized individuals. Employers cannot specify which documents they will accept from an employee. The refusal to hire an individual because the documentation presented has a future expiration date may also constitute illegal discrimination. Section 1, Employee Information and Attestation. Employees must complete and sign Section 1 of Form I-9 no later than the first day of employment, but not before accepting a job offer. Now, are you able to highlight that? See how it, look at this. Last name, and then in parentheses, family name. First name, and then parentheses, given name. So, we all know that first name, last name puts you in their jurisdiction as a corporation, but they also, they're basically saying you could put your last name / family name, either one you could put down here. You could put your first name / given name, which is your common, your first name, or your first name and middle name. And I don't know about middle initial. I wouldn't go there. Under given name, I might just put my first name - middle name. What do you think?
Yeah, you can do that, definitely. And on many federal forms, you're going to find that they put the last name first, right, as opposed, and the family name first and the first name afterwards, as opposed to the state forms.
Right.
Yeah, you're going to find that a lot because under the federal, it's under the trust, right?
Mm-hmm. And then look, so, I attest under penalty of perjury that I am. Check one of the following. They give you options. A citizen of the United States, a non-citizen national of the United States, that might be me, a lawful permanent resident, or an alien authorized to work. So that's your remedy. Listen, we didn't have to create no template or some private administrative process putting a lien on the employer for not hiring you. We found the Department of Homeland Security's form for you as a non-citizen, non-resident alien American national to fill out the form. You just got to know what you're doing and know how to use a Google search engine and pull up the form.
Yeah, and read the instructions. The instructions are right there, right?
What do you think about what do you think about on the other form that you had? It said, and on all these forms it says single or married. Do you think that that's a sinister putting you in their jurisdiction anyway? You might want to just put something else next to it, or check it out.
Who is married? Are you? It's not your marriage. Is your straw man merged with another straw man? Right. It's for benefits and privileges, right?
Yeah.
Because it gives you a tax status or some other status, right? So it's once again it's legal classification, right?
So now, do you
because
you want to elaborate?
No, I'm just saying. So when you have two entities that come together and they merge, right? That's the union, right? So that's what they're looking for. They're looking to see, is your straw man tied to another straw man?
Well, yeah.
Yeah.
What I'm saying is, do you think it's a bad thing for someone to check off single or married, or should they write something in the column? I don't know.
Oh, I don't fill out any of those things, right? I don't check any of those things. Like, for instance, all you do is put in because all you're doing is putting in your information, right?
Mm-hmm.
And then you're putting your nationality, which would, like, for instance, let's say non-citizen national. All the other stuff is, well, this one they're not asking for married or whatever, but in the W4 they were asking it. So I told you, where is it?
Foreign look,
I don't have it.
I mean, they have foreign passport number. You could write in your WSA, World Service Authority, if that's what you have. You know?
Yeah. Yeah. I've used the WSA to set up my general post at the General Post Office. So, you know, and I've used it to get into federal buildings, federal courts, and stuff like that. I haven't traveled with it yet. I'm looking forward to trying.
Yeah, but I know we both know people that I personally know people that have, and they showed me their passport. It's stamped from multiple countries. You know,
okay,
it works. Yeah, testation on there's a testation on their website of people having massive success traveling with that, and it's got the countries that people travel with no problem, and it's got ones that work 80-20% of the time, and ones people have issues with. But I think the majority of the countries on there. I mean, look before you're going to travel, and you can also call the customs and DHS and all that and say, hey, I'm leaving and coming back. I just wanted to check, make sure, I don't have any problems. I have this ID, I have this, so you can get ahead of time, what country you're going to make sure you can get there, you can come back.
What I hear people having, the problem is mostly with people coming back. They get it. They get a hard time.
But if you give them notice and you let them, and you're asking them, then they've got to.
They recommend you traveling with your birth certificate when you're coming back, so that they you can prove that you were here before.
Right. Now, does that have to be authenticated or just a certified copy? What do you recommend?
I would definitely get it authenticated on the federal level.
Yeah, but with the full faith and credit, there's no way they're not allowing you back in.
Yeah, because that's a government document right there, showing that you have a right to be here, as an American national. Yeah, but if there's not any more questions, I think we've went over a lot of information tonight. I don't want to overwhelm people. We just wanted to go over the importance of nationality and status and standing, how it affects everything, and all your interactions.
Do you want to, it's great material, my friend. Do you want to, just for the sake of letting some people interact a little bit, you want to take like 2 or 3 questions for anybody that maybe has their hands raised? There's 2 people that have their hands raised, so that's not a lot.
Sure.
You might want to try it, especially to get familiar with this webinar system so we can use it in the weeks coming forward. On the attendees section, there's 2 people at the top have their hand raised. If you unmute them, one at a time, they can speak into the mic if they have their mic hooked up. Or I think maybe I can do it. Yeah, Adam is unmuted.
Hey, can you guys hear me?
Hear you loud and clear.
Okay, cool. You were talking about we become the trustee and therefore responsible for the debts and that type of thing. So the way we were taught is we recreated the trust and then named ourselves the trustee, appointed a second trustee, and then that basically gives us control over our re-expressed trust. So is that is the position we want to be in, correct?
Yes, but the constructive trust I'm talking about is not the initial trust that's set up for the estate, right?
Okay.
That one you are the grantor, right? And you are supposedly be in the position of executor, right? Because you are still alive, right? You
Right.
are the grantor and the heir of your estate, right?
Okay.
What happens is because we are ignorant and we're incompetent, what's created is a constructive trust, and a constructive trust is what's called an equitable remedy. Can you guys see it on your screen right now?
Yep.
Yes.
All right. So this is an equitable remedy resembling a trust, implied trust, imposed by a court to benefit a party that has been wrongfully deprived of its rights due to either a person obtaining or holding legal right to property which they should not possess due to unjust enrichment or interference, right? So what's an event that can generate a constructive trust? The defendant breaches a duty owed to the plaintiff. The most common such breach is a breach of fiduciary duty, right? And so when a constructive trust is created, like I'll give you an example, when the IRS brings a claim because you didn't pay the tax, right? Or the tax on the estate, or the tax for the entity, right? You as the trustee of the constructive trust breached the fiduciary duty because you're not handling the affairs of that trust,
Okay.
right? Yeah, so that's what we're specifically speaking on, not the trust that is created from the estate. See, what happens is when a person is born, right? Your status is created, and your status also means estate, which is where you stand in relation to your assets and your estate, right? That's where the term status actually comes from, is from estate, right? And so when that estate is administered, right, I want to show you something. Hold on, certificate. I know we're jumping around a little bit, but this will make it very clear for people.
So is my constructive trust collapsed now
it's
that
not your constructive trust. It's a trust that they created, and when it says court, it's a probate court. Certificate. Hold on, I'm looking for. I found this definition earlier on today. For a certificate is actually
paper establishing the ownership claim?
No, actually, there's a more specific definition that I've overlooked. Okay, under the law dictionary. Let's see. A written assurance or official representation that some act has or has not been done, or some event occurred, or so legal formality have been complied with, particularly such written assurance made or issuing from some court, and is designed as a notice of things done therein, or as a warrant or authority to some other judge, or court judge or officer. So this is important. A certificate is something issued by a court. So what is the birth certificate?
Issued by the court.
What court issued it?
Probate.
What court? Who signed it? Exactly, the registrar, right?
Okay.
Probate court.
And the registrar is the officer of what court?
Probate.
Yep.
Why am I muted? Oh, I'm unmuted. Yeah, probate court.
Yeah.
It's not there, but if you look in Bouvier's, it says
probate.
Yeah.
Or and if you Google and pull up a birth certificate and look at your birth certificate, on the bottom it says registrar on it.
Yeah.
Inspect it carefully. We're trying to wind up and wrap up the webinar now, but you guys can do your homework and you can confirm that it does say that on there. Most birth certificates.
Yeah. So what that means is that so an estate was created, it was probated because the infant was considered abandoned, right? And the state adopted that infant, right, under the doctrine of parens patriae, right? And so, since the infant was abandoned, there's a breach of fiduciary duty, right, by the parents, and the infant was deposited in a foundling, right, which is the hospital, right? And so the constructive trust is created, and so what happens is if you don't rebut that by your 18th birthday, you become responsible. And so if you don't handle, administer the affairs, or you don't claim your estate at your 18th birthday, you consider you lose your rights, right? You don't have your recoupment. So when that constructive trust is created and you don't administer the affairs, you're brought in as the fiduciary who breached the duty. And so that is the constructive trust we're discussing. But when you understand what a certificate is, if you understand the process and how this is all created, you understand how we are indebted and how they create this whole system. And through their codes and statutes, they create these hypothecation events. So they administer that estate because the executive's office is empty. It's vacant. Does that make sense?
Right. Okay. So now that I've re-expressed my trust, so
yes.
I've now claimed my estate.
Yeah, you've made your claim and you've appeared, right? That you're not dead, you're not lost at sea, right? Now you did the first step of correcting the status and making yourself the holder in due course. Now the next step is to be the holder, because now you, as the executor, you have to collect all the debts and the assets of the estate. And some of the assets of the estate are some of these instruments that are out there trading, right? So what's
that? How the holder in due course? You said the holder in due course. Is that
there's a holder and a holder in due course, right? The holder is the one who's in possession of the instrument, right? The holder in due course may not necessarily be in possession of the instrument, but they're the ones entitled to enforce it. Does that make sense?
Yes. And
right.
So you for instance, become the holder in due course of your birth certificate, right? Or is this just any like
the birth certificate is just a certificate? It's just a certificate representing title, right? So one of the things you may want to consider is getting through the law of authenticum, getting that birth certificate authenticated on the state level and on the federal level, so it becomes an original.
Okay.
See, a certificate or a certified copy. Yeah. Well, if you're holding an original, you're the holder in due course, right? And the holder, right? Because if you're the grantor, right, and you claim your estate as the heir, the rightful heir, right, and you're holding the original, aren't you not the holder and the holder in due course? Then you can collapse the constructive trust. Does that make sense?
Yes, sort of.
If it doesn't make sense, it's okay to say so, because we're dealing with something very, like, this has never been, like, broken down for people, right?
Very complex. Maybe you can draw a map in the future for one of the next webinars, draw a little bit of a map and connect the dots about these two overlapping trusts.
Well, actually, next week I was going to go into detail into the 1933 bankruptcy and into the securitization in the Federal Reserve and into actually HJR. I was going to go into the different hypothecations and different. I was going to go into that in detail next week.
All right. Yeah.
The Trading with the Enemies Act and
yeah, it sounds good. Yeah, because eventually
this week
there's a few overlapping trusts. You got a strawman trust, a court case trust, a constitution trust, that constructive trust, making you obligated and responsible. So maybe at some point we can draw a little map out here. But Murphy has a question too. Can we take his question and then we'll wrap it up before 10 o'clock? Does that sound good? So Murphy, you're unmuted, my friend.
Sure.
I'm good, actually. I was actually going to comment about the authenticated birth certificate and how you guys covered it great, though, about the holder and the holder in due course. Because once you got that authenticated document back and you attach an affidavit to it, an affidavit of ownership, then you become, well, the way it was taught to me is you become the real party of interest. But I'm beginning to think that becoming the holder and the holder in due course is, along the same parameters. But, well, I mean, we did look up those definitions.
Yeah, real party interest is in regards to a specific case, right, or a specific claim, right?
You're right, you're right.
Due course, yeah. But you're right, you're talking about the Rule 220 affidavit, right?
Yes, I am.
Yeah, I actually have a copy of it here. I'm going to bring it up for people real quick so they can take a look at it. Then this is under the Certificate of Deeds, right? Registrar of Deeds.
It's talking about how you register. It says something in the law about registering it with the Registrar of Titles, and he was talking about how when you file a UCC1, there's a little box that you can check off non-UCC on, and if you check that, it puts it right into the Registrar of Titles, like. It would be considered like, a real estate land record. That department of your county is where it puts it in. But the non-UCC is what makes it a real public record.
Yeah, exactly. I'm actually familiar with Jonah Bay. I've listened to quite a few of his podcasts, and he's very insightful and
Hell yeah.
very comprehensive.
Definitely.
Rule 220 affidavit. I know I have it here. All right, I'll have it for you guys next week. I don't want to keep people much longer, but I do have the Rule 220 affidavit, and it's a very powerful document because it establishes you as the as the owner of that document, as the person that is listed on that document. So I appreciate it. That's a great contribution, and these are all statuses in commerce and at law, being the holder in due course, real party interest. This is where we want to get people to start thinking and tying things together. So, like I said, we don't know everything, but we're glad that you guys are taking what we're giving and you're applying it to what you already know and beginning to see it all come together. And I'm telling you, once you really get understanding of what's behind the scenes, how the machinery works, you'll be able to create your own remedies. I promise you.
I wanted to bring up that it's something important about putting it in the commercial registry. I don't agree with doing your original status UCC1 filing as a non-UCC filing, but people can have their own opinions and reasons. But I've seen people dismiss and win and discharge case after case. I don't believe in the non-UCC filing.
No, the non-UCC is for the Rule 220 affidavit for the
okay. It's not for the original secured party UCC one.
No. It's.
But knowing
after you go ahead.
Knowing the two distinctions and what happens when you check it off and when you don't check it off is kind of helpful for people. Maybe we can go into it at another time. I think we went over some of that on a previous webinar for the status course people. I think it was like week 4. We went over the UCC forms and stuff. And obviously you can go off on little tangents and spend 3 hours on every little tangent. So people can go as much in depth as they want. That's why in our course we have we pair people up into 2 or 3 people in their local area. People make a friend that lives in the same city or the same state as them, and they can spend as much time as they want. If they don't have anyone that they know yet that they can study with and spend intricate amounts of time going into these different areas and coming up with new questions to bring on our webinars. So for those of you that are not on our status correction course, obviously I have to plug that it's getting wonderful feedback, and it supports us full-time working on what we do and doing full-time research and development, and pays for our travel expenses and so forth. So if anybody who's on here for a sneak peek wants to get on our status correction course, we invite you to give us a call during the daytime or the evening time or the night time, 505-340-3632, and just ask about the status course. You can check out our website, understandcontractlaw.nduwin.com, also understandcontractlaw.com, and you can see all the feedback. There's about 12 or 15 testimonials on the main page from emails of how great feedback we're getting from the course. And so this is kind of a sneak peek of what we've been doing. But we go intricately over the UCC forms, helping people to break down, understand the instructions, taking people's questions. But obviously there's more, there's more to go into as well. And Murph is onto something there with looking into the non-UCC for different purposes, the different boxes on there. I'm big on the Bill or Bailey box, when and with what forms you're checking that off. That's important to be aware of. Anyways, I'm going to turn it over to you, Grant. You put some final, anything else you want to finally cover or reiterate, and then we'll wrap it up.
Well, I just want to thank everyone's time and attention, and I appreciate it. Don't take it lightly. I hope that everyone got value this evening and you learned something, and you have something of value that you can take away and implement right away. Next week we'll have a more coordinated and more structured webinar. We're going to go over specifically a lot of the questions that you guys had regarding instruments, regarding the bankruptcy, regarding specific remedies, especially when it comes to the discharge of debt and cases. So we understand what you guys want, but people have to understand that it's a process, and it's more important to know and understand the problem, which will help you deal with it, as opposed to just putting a Band-Aid on there. Because we have to be responsible, right? And so that's not only the ability to choose our response for any given situation, but also the ability to understand that there's nothing that happens to us that happens through us, and we've entered into these contracts even though unintelligibly and through ignorance, but now the veil is lifted, so we have to take responsibility and honorably discharge all these obligations. Yep, very well said. And you had a problem with your internet router. You got a late start, so we apologize for that. We really do. We really try our best here, but sometimes we get technical difficulties and delays. And I sent out the email and it gave the wrong link, so we're going to get on board. And because of that, we apologize. We're going to do the next 2 weeks. Even if you're a free member and you're not officially in the status course, we are going to do the next 2 weeks. So look out for your email, and you will get a notification at least a few days ahead of time for next week and the following week. Grant, we're going to do same time, same day the next week. Yeah. Next week, so that people will remember it, and it won't be a surprise or anything like that. Yeah, we'll be starting at 7 sharp, 7 to 9 Eastern. Yep, Eastern Standard Time. Okay, so we want to give people a little more info because we got on late and so on and so forth. So instead of doing 1 sneak peek, we're going to do 3 sneak peeks. So even if you are a free member right now, then you can check out the following week and then the next week. So we hope that you appreciate it. We hope that maybe you tell someone who is studying this that they can get on and get some really great quality information. And I will put these documents up under the free documents section on the Understand Contract Law website within the next 24 hours or so. So look for that, and you can read this all in your own time. And yeah, we do appreciate everybody, and I really appreciate Grant, you taking time out of your super busy schedule. You are a high-level, consultant, financial planner. You consult and coach multimillionaires on legal entity construction and jurisdictional selection of
their international businesses and trusts and wills and estates and all that stuff. So I know that your time, because we're friends, you give us the benefit of the doubt, and you understand that there are people out here. It's more about money. I know you charge a lot of money per hour for your consulting with high-level people, but you're doing this kind of as a favor to me and to us. Not really what you should be being paid for your true energy, your true talent, and your true intelligence and tireless study over the last few years. Not just on your own study, but you spent your own money traveling around the world, meeting with people, traveling in a car, 1,000 miles to different areas of the nation.
Yeah.
I really appreciate your effort and us being able to collaborate and try to break this down for people who are the beneficiaries of our tireless.
And I also want to stress. Yeah, I appreciate that. Thank you. And I also want to stress there's nothing that we're going to discuss or offer that we're not living or we have not experienced or we know someone personally who's have experienced success with. We don't teach theory or we don't share theory. And when there's something that hasn't been tested or something that we're not clear on, it's an opinion, we will let you know. But everything that we've talked about tonight, we've either implemented or we're living. All right, so just know that. We're not out there teaching theory.
Well, with that, hold on. James has his hand up. Let's just see. James, do you have a quick question?
Yes, quick question.
Sure.
I want to ask, okay, I copyrighted my birth certificate and I attached it to a UCC1 financial statement as an addendum. Would that be enough to make me hold in due course?
Brant, you want me to answer that, or you want me to answer that?
Well, the birth certificate you're talking about, is it authenticated or is it just certified?
It's just the regular birth certificate you get from the court, from the clerk of the county.
That's not authenticated because the clerk is just an agent or appointee or a delegate of the Secretary of State. The notary, the public notary, right, is an elected position. And the only official notary of any state is the Secretary of State. So for it to be under the law of authenticum, that Secretary of State would have to authenticate on the state level, and because the birth certificates are sold to the federal government, you want to get it authenticated from the federal level, then that would be an original instrument. Now, in terms of the copyright, I can't speak to your copyright or your process, because the birth certificate is not really something you can copyright because you're not the author of it. So, without getting too much into detail, like, I don't know what process you're using or where you got it from, but these are the things that we're talking about, that there's a lot of information out there and people telling people to do things that's either incomplete or incorrect. Does that make sense?
Yeah, you can't copyright that, but he might be talking about the copyright notice or not. I'll unmute him again in a second to have him have the last word, but there's more. The authentication thing is one step that you can do. I'm under the belief and understanding, and from the successes that I've seen, that you can successfully challenge a jurisdiction of the court and win if you got all your paperwork in order. I don't want to leave things out that are significant and across the board correcting the status from my point of view. So from my point of view, you've got W-8s and Form 56s that change the trust from not a 1040 taxpayer but a 1041. You got a different EIN number for an irrevocable trust from the IRS. You got a hold harmless agreement and copyright notice. There's several things. We go over that in the weeks 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14 of the curriculum that we've done already. If you've missed all that, we do have it all recorded with all the documents that we can send to you in exchange for donation to support our efforts. We have several, members, contractors, staff members that work full-time with our organization, so we do request a contribution for, I personally started working on this over a year ago, so it's not, it's not like we haven't put tremendous amount of efforts putting together, you know, everything. But you can get with us if you're interested in that. But there's a lot of other things from my point of view that I've done that all line up and are tied together. It's not just doing one. I think people have the misunderstanding that you can just go and authenticate your birth certificate and that's the only thing you need to do, and now your status has changed. There's more to it than that.
Absolutely. There is a series of things.
Yeah.
People did not get into all these adhesion contracts overnight. The authentication of the birth certificate is for one specific purpose in terms of having an original, because unless you're willing to open up a claim in the surrogate court for them to give up the original birth record to you, the authenticated birth certificate is the closest you're going to get to having an authenticated document, which makes you the holder and being able to, under the law of authenticum.
James, I wanted to, just in case you want to clarify on your question, or do we kind of? And we're trying to wrap up the webinar, so we're trying to just kind of, we can take more questions next week and the following week. There are going to be free webinars open to everybody on our list. But James, you're unmuted again in case you wanted to elucidate or add one more thing. You can go right ahead.
Yeah, you guys hit it right on the head for me. Exactly what I needed to know. But I want to know, like, by me copywriting my birth certificate from the county, do that cover anything? Like, that's like, would I be able to sue a police right now for writing me a ticket, for putting my name on a ticket without my permission, because I got my birth certificate copyrighted?
I don't think so. You gave him your permission when you signed the DMV application, and when he stopped you, did you give him a driver's license?
Uh-oh, I dropped him down on the list there. So give the answer.
So basically, by filling out by filling out the DMV application, you agreeing to be bound by the motor vehicle laws. And what happens is when they stop you, they're acting under the presumption and assumption that you have agreed to it. And when they ask you for your driver's license and registration, you hand it over. You confirm that presumption. So
basically, if the car is registered in your name and you haven't corrected your status and you've got a certificate of title issued from the car, you don't own the allodial title to the car, and you get stopped and you don't provide a license, you're in contempt.
Yeah, guys, leave that traffic stuff alone. Choose your battles, especially while you're learning. Please, I went through a year of traffic court, and it was not pretty. I learned a lot, but it cost me a lot of money and time, and I'm telling you, it's not worth it. There's better things that you can spend your time learning, okay? It's not the best use of your resources right now.
Yeah.
Yeah. Leave that traffic stuff alone. Like, it's not worth it right now. There'll be a time for that.
Yeah, and we're going to go over in future webinars how to get the MSO, how to international driver's permits, different things like that. But everything that you're learning on these presentations, and then taking the time, if you have a study partner, if you're in our course, and you are going through the suggested homeworks and suggested optional study as much or as little as you got the leisure to do. Everything that you're learning all ties in together. Just because we're not going over right now how to get an IDP or this and that or whatever, doesn't mean that this isn't going to be helping you to do that. It all ties in together. So, I guess, what do you want to do? Bring everybody's questions and stuff on next week, or?
Yeah, let's close for tonight, and appreciate your time. Appreciate everyone's attendance and your participation. You all appreciate it, and everyone have a good night.
Okay. Well, thank you. You stayed a little bit later because we got on late, and we feel a little obligated to people. So if you got questions still on here, just bring them on to next week, folks. We appreciate it, and we want to respect the guest presenter's time. So once again, Grant, thank you so much. We will be here next week. Everybody, check your emails. Have a good night, everyone.